Good afternoon. This is the House Judiciary Committee. It is the 7th of February, 2024. It's a little after 2:30, and we're going to get started with our bills, starting with Delegate Kaufman's bill, House Bill 432. Delegate Kaufman, if you'd like to begin, please.
The fancy dancy. Oh, here it goes. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and esteemed colleagues. For the record, my name is Delegate Aaron Kaufman, representing District 18. This fall, I was honored when the Attorney General's office asked me to introduce HB 432, which would change the term mental retardation, a phrase this disability community considers a hurtful slur, to the appropriate medical term of intellectual disability in the Maryland Code of Law, or also known as the Criminal Code. So I'm channeling my inner David Moon today. An intellectual disability is described as a condition characterized by both significant limitations in both intellectual functioning and adaptive behavior. This change was made by the federal government. The change from mental retardation to intellectual disability was made by the federal government early in the Obama administration, and prior to federal action, a bill sponsored by Vice Chair Bartlett's predecessor, the late Delegate Ted Sophocles, attempted to remove the term mental retardation from Maryland law. While the bill passed, it was not entirely successful. The derogatory term of mental retardation has no place in our criminal code. Friends, this bill is personal to me. As all of you know, my brother Jay had an intellectual disability and passed away a year ago this week. So I am carrying the bill forward in his memory. I'm not fond of labels as they relate to people with disabilities, because people tend to focus on the label that the society has given a person rather than actually getting to know them. However, diagnoses are essential to receiving services. This bill allows us to refer to people with disabilities in a respectful manner. In full disclosure, after submitting this bill, I learned from bill drafting that the change is already occurring in this year's technical corrections bill. However, the Attorney General personally asked me to continue to carry the bill because he believes, and I agree with him, that the General Assembly needs to make an affirmative statement that this derogatory term has no place in our criminal code. Given the ideological diversity among the co-sponsors of this legislation, I believe my colleagues agree with me and urge a favorable report on House Bill 432. And before I close, Mr. Chair, because I have an extra couple seconds, I just want to say the opposition makes no sense to me. This bill has nothing to do with the LGBTQ community. It has nothing to do with Planned Parenthood. If it did, a bunch of pro-life legislators that are on the bill would not be. So it's a simple but meaningful and impactful change. And now I'll take any questions, but I now turn it over to my star witness, Ms. Megan Jones. And you will note, finally, that the judiciary is in support of this bill.
Okay. Good afternoon, delegates. Thank you, Mr. Chair, for the opportunity to address this committee. And thank you, Delegate Kaufman, for sponsoring this bill. My name is Megan Jones. I am the Vice Chair of the Maryland Developmental Disabilities Council. We are an independent organization that works to create change and improve the lives of people with developmental disabilities in Maryland. The council has submitted a written testimony. I am here on the behalf of the council to support HB 432. I was born with Down syndrome. Having Down syndrome does not mean other people should be allowed to tear me down because of my disability. The same goes for my fellow council members and thousands of other Marylanders who have intellectual and developmental disabilities. Right now, certain Maryland laws, outdated language that is hurtful. 15 years ago, Rosa's law removed of this language in Maryland. But it remains of the course of the judicial proceedings, and criminal procedural laws. It is time to remove this language from these laws as well. Marylanders with disabilities like myself deserve the same respect that everyone else gets. By removing outdated language in our state and choosing words do not hurt them. Others, we ensure that
Keep going, keep going. It's okay. Wrap
the
up.
council supports replacing this hurtful language with the term intellectual disability. This change will positively impact how everyone across Maryland looks at those with us, of us with intellectual and developmental disabilities. For these reasons, the council supports HB 432. Thank you for your time.
Thank you very much. Are there questions for this panel?
And I don't know if somebody from the AG's office is here, but they did.
Yes, they're signed up. There's a representative from the AG's office signed up, representative from the State's Attorneys Association. Why don't you all, you want to come on up? We'll take your testimony right now. Corinna Rossi from the Office of the Attorney General. If you would use Delegate Kaufman's. All right, we'll hear from Ms. Rossi and then Patrick Gilbert. Right? Okay.
Yes.
All right, we'll hear from Ms. Rossi. Go ahead.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the committee. Assistant Attorney General Corinna Rossi on behalf of the Office of the Attorney General, asking for a favorable report on House Bill 432, which would replace references to mental retardation and insanity throughout two portions of the code, as mentioned, Courts and Judicial Proceedings article and the Criminal Procedural article. The continued use of a slur to refer to juveniles and criminal defendants unnecessarily demeans them. And this bill reflects the understanding that the language we use to refer to others matters. On two prior occasions, the legislator has recognized as much by eliminating this sort of offensive language, as noted first with the passage of Rosa's Law in 2009, and again in 2016 when it eliminated these types of references from the criminal law article. This is simply the next step in that effort to remove such language from the code. As this bill reflects, these derogatory terms can easily be substituted with phrases that accord juveniles and criminal defendants the respect that they deserve without necessitating any substantive changes. For these reasons, these two portions of the code should be updated to use language that refers to juveniles and criminal defendants in a dignified manner. I'm happy to answer any questions and urge a favorable report.
Good afternoon, Mr. Chair, Madam Vice Chair, and distinguished members of the committee. My name is Patrick Gilbert. I'm a Senior Assistant State's Attorney from Wycomico County. I'm here this afternoon on behalf of the Maryland State's Attorneys Association to add the voice of Maryland prosecutors to the chorus calling for a favorable report on House Bill 432. We have an obligation to ensure that our laws and the language we use in administering them reflects our values. As Delegate Kaufman noted, Marylanders pay attention to what goes on in this body, and it takes that tone that this body sets, and issuing a favorable report on this bill would telegraph to all Marylanders the dignity that everyone in this state is afforded. This body's heard from witnesses more compelling than I, so I won't belabor the point. There's every reason in the world to issue a favorable report on this bill and not a single one not to. Thank you, and I yield to the committee's questions.
Seeing none, thank you all very much for coming today and for your testimony. You have one person signed up to testify in opposition. His name is Ayo Kimathi. You have 2 minutes.
Thank you for allowing me this opportunity to address the council. Thank you, Chair. I'm against this bill, and as opposed to speaking it, I'm going to read the testimony that I have uploaded with links applicable for you to look and investigate yourself. My name is Ayo Kimathi. In 2023, I testified against many bills proposed in Maryland that were seeking to sexualize children. I am writing this testimony to share my concerns about targeting mentally disabled children and adults for sexualization. This bill appears to be a part of the SHINE initiative of Planned Parenthood. A link to the SHINE initiative where you can see this exact language is included in the testimony I submitted. Essentially, what Sexual Health Innovation Network for Equitable Education, SHINE, does is to legally allow sexually perverse LGBTQ doctrine to be taught to mentally disabled people. They do it by classifying it for people with intellectual disabilities, the exact same description that is being used here. This appears to me to be why Maryland is now trying to change this classification. It appears they are actually training the mentally disabled how to be an active LGBTQ participant. This is absolutely and utterly appalling abuse of the mentally disabled. It appears that people are trying to sexually exploit people who we're supposed to be trying to help. It disturbs me, and I thank you for the opportunity to share this. Please investigate it for yourself, and let's protect, not go after them sexually.
Questions? Seeing
Thank you.
none, thank you very much for your testimony. That concludes the testimony on House Bill 432. We're going to move now to House Bill 264, and Delegate Crosby, please. Panel number one, Delegate Crosby, State's Attorney Sterling, John Duckett, Ms. Green, Shalinda Green. You want to come this way? Delegate Kaufman, if you want to start making your way up that side, that's fine. And we'll, or no, it's right in front. Just come straight ahead, straight ahead. Right. And here is Mr. Vice Chair.
All right.
Whenever you're ready, go ahead.
Good afternoon, Mr. Chair, Madam Vice Chair, members of Judiciary Committee. For the record, Delegate Brian Crosby, and I am here today to present House Bill 264, Jamari's Law. This legislation is named after Jamari Duckett, a young man from St. Mary's County, who I personally knew and have interacted with him several times. And last year, Jamari was killed in a car accident caused by a drunk driver who was found to be driving at speeds between 76 and 91 miles per hour in a 40-mile-an-hour speed zone. Jamari was only 18 years old. Under the current law, a first offense for manslaughter by vehicle or vessel gross negligence carries a maximum of 10 years in prison, while subsequent offenses carry a maximum of 15 years. Since such a crime is considered a nonviolent offense, those convicted could be eligible for parole after serving as little as 1/4 of their sentence. That means that even when a person is sentenced to a maximum sentence, they can still be released from prison only after serving about 2.5 years. Although the driver who killed Jamari Duckett was sentenced to the maximum possible sentence of 10 years in prison, he could still be released in a little over 1.5 years from now. This bill will increase the maximum penalties to 20 and 30 years respectively. And it is important to note that this bill will not create a mandatory minimum. It will only give judges greater flexibility when sentencing people found guilty of the crime. You're going to hear from many of the families who suffered similar tragic incidents. But I would like to first turn it over to our state's attorney, Ms. Jamie Sterling, and then I will allow Jamari's parents to speak.
Good afternoon, Mr. Vice Chair, Mr. Chairman, I didn't demote you. Good afternoon, Mr. Chairman, Madam Vice Chair. My name is Jamie Sterling. I'm the state's attorney for St. Mary's County. It's an honor to be before you in this committee, and we have a critical bill that we have brought before you and we believe is urgently needed. A lot of our job as prosecutors is to ensure that justice is sought and we find the truth. In the courtroom, my job is to ensure that the innocent are to remain innocent and that we prove only the guilty and get convictions for the guilty. In this instance, for vehicular homicide, it is considered a nonviolent offense and it's a 10-year felony, but it's no different than any other homicide. But we do understand that when someone gets into a vehicle and commits this crime, we understand that they don't get in the vehicle and say, hey, today I'm going to drive and kill someone. Because if we did, that would be a first-degree murder. So we understand what type of homicides they are, but they're no different. This is not different than someone who utilizes a gun or a knife. This is a vehicle, and it's unimaginable what a vehicle can do to a human body. It is still death that results. And what we're seeing in the courtroom is with the maximum penalty of 10 years, and it's considered nonviolent, these offenders, if they're even given 10 years, are released at 2.5 years. And the stories that you're going to hear are from these families who have lost absolutely everything. And in these homicides, which are different than the homicides that you're used to hearing from, the ones that involve firearms or knives, in those homicides, in our world, we'll say that they're a little bit more sterile. We have to see the Office of the Medical Examiner reports, and those are usually a bullet wound or a knife wound. These are absolutely devastating. They're mutilating most of the times, and sometimes families are decapitated or burned. They can't even have open casket funerals for the loved ones. These are in fact murders, and we want to bring this before you because as prosecutors, there's nothing else that we can do except for to ask for the max. And I believe that 10 years is just insufficient for a homicide and this type of homicide. And I am going to wrap it up quickly. I know I have 2 minutes, but I just wanted to add just a few things, just to put it in comparison. The 10 years in our judicial system, that equals pushing someone, which is a second-degree assault, a bar fight, that's a second-degree assault. That has the same amount of time as this 10 years. But if we put it in a monetary value, this vehicular homicide, which carries 10 years, is the same as stealing $25,000 from someone.
Right.
So if we're valuing life, that's what the value would be, and we think it deserves more.
I'd like to hear from the family that's here, so please.
This is Miss Greenwell, and this is Jamari's mother.
Hello, everyone. Jamari was my son. I'm a little nervous, so I wrote something. My life changed the night when a drunk driver recklessly took my son Jamari away from us. Jamari was a bright and ambitious young Black man who laid out his path to success with college as his next step, only to have a careless drunk driver block his path with a fatal blow from a truck plowing down on him like a tank to a bicycle. He had no chance. This is reckless and a disregard for life when you get behind the wheel drunk and driving over the speed limit. That could have been you, me, your kids, parents, or grandparents in that car. And to only get 10 years and out a few years later on probation is a slap to all families that has lost someone to a drunk driver. Send a message and increase the penalty for that is what it is with the vehicle. Is no difference than a gun, just a bigger bullet. I know Jamari was going to contribute to make the world a better place to live. So let's help him still accomplish his goal and pass Jamari's law.
Yes, I'm Jamari Duckett's dad. My name is John Duckett. Like Jamari's mom said, about 1.5 years ago, we lost Jamari to a drunk driver. That morning I got the phone call. It changed my life forever because I wasn't expecting that phone call. I was expecting a phone call for him to come to work and be there. I was ready to argue with him because he was going to be late. And little do I know that, you know, of me, because I was always, man, to be early is to be on time, and to be on time is to be late, and to be late is to be forgotten. And so I was thinking that he's going to be late, and the whole time he was in a very bad accident. And I didn't even know that. I'm ready to argue with him because he's going to be late to work. And the whole time now I can't even get him back because of someone's negligence. I was training him. He started working with me when the pandemic started back around. He was 14 years old. So he started working, handling money at a restaurant. And me and him became like really, really close. He was my guy. I called him. He took care of his little brothers and little sisters. He was like my the guy that was between us that would, when me and his mom wasn't having our right times, I could call him and he would make everything right. And this was when he was 14 years old. So I was counting on him like at a younger age. And then as we worked, long as we worked together, he became more dependable. So I was building him up to be an asset to this world. And that guy took an asset away from this world. So I ask you guys to please find it in your heart to make this law changeable, because we do not want anyone to feel the pain or have to endure that phone or hear that phone call and to say that a family member is gone. So especially from a drunk driver. So please find it in you guys' heart to make this bill passable. And I thank everybody for their time. Thank you.
Are there questions for this panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Thank you, family, for testifying. I know it's very hard. To the delegate, good delegate, what happens when the manslaughter by a vehicle involves a pedestrian that jaywalks against the green light? They walk out maybe in the middle of the street, or just walk out of an alley or something and get hit.
Sure. So there are, I think you're talking, the example you might give is maybe something more of what we would classify as maybe something that may have been a motor vehicle accident versus different levels of, there's motor vehicle accident. Sure, those kinds of things happen. And then there's criminally negligent manslaughter. Then there's this, which is gross negligent manslaughter. And then there's the example of first-degree murder. So the example that you might give, depending on the facts, might just be a motor vehicle accident, which would be maybe more civil in nature, which a death may have occurred. But there are gross negligence is the standard. So an example like that likely would never reach gross negligence.
Right. I was just trying to get you to put it on the record, how the speed might affect the severity of the charge. You didn't explain that.
Sure. So just the speeding charge that results in a motor vehicle collision, again, a speed alone wouldn't necessarily raise the level of even criminally negligent, which is a misdemeanor. But this vehicular homicide, which is a gross negligence standard, is a felony. So it would be a different, if it was just speed alone, it would have to be maybe something much more egregious, like maybe speeding at 100 miles an hour in like a 10-mile-per-hour zone where you know that it's a park. It would have to be something that was just so much more grossly negligent. And additionally, there are more victims' families that are here.
Okay, thank you very much.
Further questions for this panel? All right, thank you very much. We'll go to the second panel, which had Monica Murphy, Megan Moves. I'm probably mispronouncing that. I see Miss Graham is standing up, but I have her on the third panel. If I will go in whichever order is best, and I know that there are victims' families who are here. So Miss Gramis, if you want to let me know who's coming up now.
Megan Moore.
Okay,
And then we have.
and the Murphys.
The Murphys are right here.
Okay, so why don't you join with them, and why don't you join with them?
Yeah. And I'm happy to answer the technical question as well that was just posed.
That's fine. We'll do that after
Thank
they
you.
testify. That's perfectly fine. But that's what we'll do. So for the people who are here and who've lost loved ones, we're not running the clock.
Thank you.
Ms. Gramis, I'm sorry, you're going to get a 2-minute clock, but having said that, we're not going to do that for the people.
May I just ask one additional, Ms. Murphy on the end has some difficulty in testifying and explaining what happened.
if I may, if she's not able to say the facts of what her case, may
That's fine.
I do that for her?
We can do that. Let's see,
Thank you.
let's see how this
Sure.
unfolds and
I appreciate
and
that.
that'll be fine. Whoever would like to go first, please go ahead.
My name is Megan Moore. I'm a lifelong resident of Anne Arundel County. I'm here to express my support for HB 264, also known as Jamari's Law. I share my testimony with the hope that you will vote favorably to advance this bill to become law. My life was forever changed on June 5th, 2021, when my son Noah was killed in a car crash caused by an impaired and reckless driver. This is my reality every moment of every day. While I struggled to cope with my new existence, I counted on our justice system to provide consequences for the driver who chose to get behind the wheel that night. The driver pled guilty to negligent manslaughter and driving under the influence of alcohol. He received a jail term of 10 years with all but 18 months suspended for the manslaughter charge, while the DUI ran concurrently with the entire sentence suspended. The driver served 9 months and 1 week. Noah, my leap day baby, was just 21 years old when he was so tragically killed. I struggle to find the words to perfectly describe him, as I will not be able to truly capture his spirit, his zest for life, his charm, and his unwavering loyalty and dedication to family and friends. It continues to take my breath away that he's really gone. I acknowledge the driver did not intend to kill Noah, but he did choose to drive recklessly and impaired, which resulted in Noah's death. There must be consequences for such careless decisions. I implore you to vote favorably for HB 264. Strengthening these penalties is crucial in promoting accountability and instilling fear, deterring others from making decisions that lead to such devastating loss. Thank you for your consideration and your commitment to justice.
Thank you, committee. My name is Monica Murphy. This is Matthew. He was 12 years old. On April 22nd, we were walking on the sidewalk in the neighborhood of Arnold with my youngest son, going to get a haircut, when a man who had already been doing cocaine in another neighboring community decided to leave that house after his friend had already overdosed, get into his company vehicle, and smoked crack cocaine in the car. Came up the hill. My youngest son at the time, who was 10, had to jump out of the way into a bush. He was on a skateboard, and I had just stepped outside onto the curb. Matthew was following behind us because Patrick was on a skateboard. Matthew was behind us because he was dragging a stick trying to make a point. And I thought the man was coming for Patrick. And I screamed, and Patrick jumped. And by the time I could run back and grab Matthew, the van had come up onto the sidewalk and drug Matthew. He decided to smoke and destroy my family instead of going home to his. He is already out of prison. He got the max. He's only spent just about 3 years. But Matthew is gone for something that he purposely did. I know, and everybody says he did not purposely go out to kill somebody, but him smoking that in that car, he did. He knew what could happen, and it did. So I please ask you to support this bill. Thank you.
Hello, my name is Douglas Murphy. I'm Matthew's father. The day Matt was hit, I thought that was the worst. We go through the court cases, you know, Carolyn is able to get a full conviction. And then we got put in with Department of Corrections. We were not notified of the bail hearing. We were not notified of his being released. So I ask you, please give them the tools that they need so that the families don't feel like a piece of meat. We're not just another number. It's just my son. So I ask you to please consider this. I know they're not going to get a full 20 years, but they're going to get something more for the families. And that's all we ask. Thank you.
My name is Carolyn Gramis. I'm an assistant state's attorney here in Anne Arundel County. I literally just came from court just now for a fourth-time DUI offender who was driving the wrong way on Route 100, causing a 5-car pileup, killing a gentleman going to work at 11:15 at BWI Airport. The maximum I could ask for was 15. She got a DUI while we were investigating the case for driving the wrong way by Howard County at the time we're investigating. And the max I could get is 15 years. Monica and Doug Murphy speak about Matthew. What you don't know about that is that he literally had a crack pipe in his left hand and a lighter in his right hand as he's driving this work van. He's lighting that and he's smoking it, even though he just saw his friend overdose out at another house. And that's where he runs over Matthew Murphy. And the max that you could get is 10 years. I bring you, this is my bulletin board in my office. This is only victims of auto manslaughter cases, except for the midshipman murder case, which I also was part of. All of these people represent the lives, the children, the mothers, the fathers that have been lost. This is the most socially acceptable form of homicide that we have. I cannot stress that enough. I constantly have to tell families, everyone just says it could happen to anyone. That's not true. It happens to people who make the decision to drink, to drive, to use drugs, and to operate a motor vehicle, and it costs people lives. And it causes this tremendous harm that I constantly have to sit and tell families, here's the most I can get. 10 years if it's a first offense, 15 if I can show that you've had a prior DUI or something else. I've had a person decapitated for a person going 110 miles an hour on Snapchatting while he's driving 110 on the phone. Rear ends a man driving 55 miles an hour on Route 10. The impact of him takes him into a guardrail, decapitating him, doing nothing wrong. The max I could get was 15 years, which is what I got. We need this bill. Not every case deserves a 20-year sentence. And to the question that was asked about whether or not you look at someone stepping out into a traffic, that is looked at. That is something that as a prosecutor, you must look at the conduct and how to make a decision. And that is not what this bill is for. I ask that you vote favorably for this bill and advance it.
Are there questions for this panel? Delegate Conaway.
Mr. Chairman, thank you very much. Thank you, panel. So I would like to ask this question. Since you brought up the Snapchatting on the phone, is this bill about distracted driving and causing manslaughter by vehicle?
Well, negligent manslaughter can carry a couple of lots of different things. You asked about speed. So
Yeah, but
normally,
I'm asking you now about distraction. You used the example of the phone, right? Snapchatting.
sure.
And so someone was decapitated because they were.
But it was alcohol. It was.
Oh, you didn't
Snapchat.
say that.
I
Thank you very much.
apologize.
I'm-
Yes, there was alcohol as well. I apologize. Yes.
Thank you. My condolences to the family and your powerful statements to reflect the loss of your loved ones. I think it impacts us all here on this panel. My question would be to our attorneys. When it comes to the citizen guidelines, obviously there's a hiccup in our system here. And how do we, with so much legislation, there was legislation passed last year dealing with vehicles and vessels. Now we're back again, kind of mirroring that same legislation. Is the gap in the citizen guidelines that we need to look at when it comes to how we are doling out these punishments when it comes to crimes? and
I
offenses?
absolutely think that is a problem. So today, the sentence, so fourth time offender, this is her fourth DUI, she's killed someone. The guidelines are 4 to 9 years.
Right.
That does not capture what I believe, and the court agreed with me that it required an upward departure. So I do believe that the sentencing guidelines does not capture for these types of crimes what it should. If you're a first time offender and you kill someone, it's always 3 months to 4 years.
Sure.
Okay, so-
Can we maybe also take a step back and look at the sentencing guidelines and how we can work to really address it, the problem? Because if legislation is passed and the hiccup is still lies within the courts with the sentencing guidelines, then we're kind of right back to where we start from when we come to this type of legislation. So I think it'd be a good idea for us to also look at the sentencing guidelines as
I
well.
certainly see your point for doing that. I'm constantly arguing for upward departures, and I usually am getting them. So I completely agree with you that would be also something to look at.
Yes, ma'am. Thank you. Thank you.
Are there further questions for this panel? Delegate Carden.
Thank you, Mr. Chair. To the families, first of all, thank you very much for telling your story, and my condolences on your loss, and hopefully you can continue to tell your stories so that we can try and motivate people to be safer. To the Assistant State's Attorney, thank you very much for your testimony, compelling testimony. My question is, does the judge have any ability, any discretion to be able to disallow additional good time or any kind of ability to require a certain amount of time to be spent in jail?
I wish that was the case. It's an excellent question. It's something that we re-victimize victims all the time. That they can't do anything about that. Immediately when someone, let's say, is sentenced to the Department of Corrections, they can go ahead and make their own determination as to whether or not that person should be put on house arrest. I have a case where a gentleman was killed by a drug driver. Within 2 months of getting a 2.5-year sentence, DOC is sending a letter saying we're going to put him on house arrest. So we have to fight again. So we've got to automatically start sending stuff saying, hey, don't do this. I can't control that, or the judge can't. But what I do try to do is just try to put all this paperwork, PowerPoints, anything that I've done in part of a case, I get to the Department of Corrections to try to kind of stem that happening, but I have no control over it. And it just falls back to the victims who then contact the state's attorney, and then we fight again. And so we just keep re-victimizing victims with these types of cases particularly.
Thank you.
Further questions for the panel? Ms. Gramis, very quickly, this is considered a nonviolent offense, so they are eligible for parole after 25%.
That is correct. And that is something else that needs to be changed because of the classification of that. They are immediately kind of processed out very quickly, and it just continues to cause victims to have to keep battling to say, hey, this is what the judge wanted. So even within the confines of what the 10-year sentence, you're still fighting that because they can undo it because of the violent versus nonviolent status. And that is something that each of the people here have testified to. And I appreciate that you recognize how hard this is for the witnesses here to testify to this. And I thank you for recognizing this because it is opening that wound every time. And I thank you for taking time to hear them.
Thank you, and I apologize. I just wanted to ask you, are you finding that individuals that are involved with these type of cases, do they seek mental health or anything mental health related? Like, for example, I've seen where people have been in DV accidents or and things of that nature, and they're put on a 72-hour hold instead of going to jail. They kind of go to the hospital for kind of the detox period and the mental health evaluation as well.
In the typical cases that I see, usually we're talking catastrophic type of cases. And so you're going to a hospital right away. So unless somebody, they will get a mental health, some kind of like consult at like say shock trauma. I'm not normally seeing that because most of the time there's some injuries that are related to that. There is a component that does come up afterwards saying, I do have a mental health. I had it today. That she's indicating that she has a mental health problem. And then we address that as part of supervised probation. We certainly make that all the alcohol and drug testing and treatments interlock, scram, and then we also make that a component because that can be part of how we got to there. So yes.
Thank you.
Can I add an answer to you to that as well?
Seeing no further questions, thank you all very much.
Thank you.
Thank you very much for coming and testifying here today. The third and final panel, we have a panel of people who are going to testify virtually as well. So I'm going to ask them to be included in this panel. The state's attorney for Prince George's County, Aisha Braveboy, is she here? Virtually? Okay, so state's attorney Braveboy is here virtually. Kurt Erickson, Patrick Gilbert, who I see, Dana Goldsby, and then virtually would be the state's attorney for Prince George's County, see? Monica Taylor, Nancy Suzik, and Carol Faxon. I see two people at the table. We will just do the best we can, and I'll start in the middle there.
Great. Mr. Chairman, members of the committee, my name is Kurt Erickson. I serve as president of the Maryland nonprofit Washington Regional Alcohol Program, which is a group 42 years old, formed to fight drunk driving and underage drinking. You've heard a lot of testimony. Let me just take 60 of my 120 seconds just to reiterate our support in this effort to counter existing Maryland sentencing guidelines for vehicular manslaughter, which can result, as you've just heard, in ineffectual and remarkably low imprisonment sentences. The bill looks to, as we've already said, increase the maximum periods of imprisonment for persons not just convicted of vehicular manslaughter, but also those convicted of such and having previously been convicted of either a number of crimes, including driving under the influence of alcohol, driving while impaired by alcohol, or driving while impaired by drugs or controlled dangerous substances. Maryland last year bore an increasing number of traffic deaths, not just last year in 2023, but also in 2022. And to this day, still over a quarter of all roadway deaths in the state still involve drunk drivers. We're simply looking at championing a meaningful deterrent and penalty for drivers who control a vehicle in a grossly negligent manner, which results in death of another, or we think that's both paramount and overdue. In closing, as a means of better equating the sentence with the lethal crime, RAP supports House Bill 264 and urges your favorable consideration of the same. Thank you.
Good afternoon again, Mr. Chair, Madam Vice Chair, distinguished members of the committee. My name is Patrick Gilbert, a senior assistant state's attorney in Wycomico County. And again, I'm here on behalf of the Maryland State's Attorneys Association to urge a favorable report on Jamari's law. There's nothing that I can add sitting here today that could better underscore the profound loss that is inherent in every single one of these prosecutions. So I'm going to focus my comments instead on the community interests at stake here and the more granular aspects of these types of prosecutions. Like Delegate Kaufman noted earlier, the people of Maryland listen to and take direction from this body and from the issues it prioritizes. In an age of increasing distractions available to drivers, at a time when we are seeing increases in fatal vehicular collisions, and at a time when we've established a commercial marketplace for recreational cannabis, now is the time for the General Assembly to reaffirm what is expected of every Marylander who operates a motor vehicle, that when you get behind the wheel of a 3,000-pound machine, you do so responsibly. Issuing a favorable report on Jamari's law telegraphs the importance of this to the entire state. And finally, one thing that I don't want to get lost is precisely how serious the conduct addressed by this bill is. Gross negligence manslaughter by motor vehicle requires the state to prove that a defendant has engaged in conduct that is of extreme or outrageous character and evinces a wanton or reckless disregard for the value of human life. This is conduct that is so far removed from ordinary civil negligence, from distracted driving. Reported opinions in our appellate courts examine scenarios like street racing in a crowded area. There's a particularly tragic case that comes to mind where a driver strikes a pedestrian and drags the stroller she had been pushing and her 3-year-old grandchild for another half mile. Plainly put, that when a jury finds beyond a reasonable doubt that a defendant has engaged in this conduct, courts need more in order to achieve a resolution that more closely approximates justice. I'd welcome the committee's questions about this bill and about how these types of prosecutions look.
Madam State's Attorney, please.
Thank you so much, Mr. Chair, and good afternoon, Madam Vice Chair. And it's me, correct? Yes. Okay.
Yes.
Madam Vice Chair and members of the House Judiciary Committee. I'm writing to, I'm here today to testify in support of House Bill 264. My Special Prosecutions Unit prosecutes, amongst other offenses, vehicular manslaughters and associated crimes. In 2023, 2023, my office indicted at least 25 cases involving vehicular manslaughter. The most heartbreaking aspect of these prosecutions is the devastation that needless deaths wreak on the families of our victims. Often compounding this devastation for these vulnerable families is the legal reality that the maximum penalty that courts can impose is 10 years, with much less executed time set forth under the applicable Maryland sentencing guidelines. For families who view the conduct that caused the death of their loved ones as akin to murder, these sentencing limitations come honestly as a slap in the face to most of them. The provisions under this bill will help strengthen our ability to ask for more appropriate sentences for this type of offense. And we hope that this committee, as well as your counterparts in the Senate, will, support what we're trying to do under this bill, which is to bring some, sanity as well as better accountability under the laws here in Maryland for this type of offense. So thank you so much, and we ask for your favorable consideration.
Monica Taylor, please. Monica Taylor, you can begin your 2-minute testimony.
Hello.
Yes, please go ahead.
I'm here to support the Jamari law, and I'm in favor of the law because I think that 10 years is not enough time for the crime that has been committed, especially a homicide. And I am here to just support his family. And thank you.
All right, thank you very much. Carol Faxon, please. Ms. Faxon, we're having difficulty hearing you.
Now?
A little, you're breaking in and out.
Sorry. Can you hear now?
You're breaking in and out a little bit. It's there connected. Ms. Faxon, I don't know if you can even hear me. If you can get to somewhere with a better connection, then we may try again. Right. I also saw Nancy Suzuki. She is there. We'll hear from her. Please go right ahead.
Mr. Chair, Madam Vice Chair, thank you for allowing me the opportunity to speak today. My name is Nancy Sefchek, and I am a St. Mary's County resident. I'm a concerned citizen, wife, and mother of 3 daughters, and I'm a friend of Jamari Duckett. I'm testifying today in support of House Bill 264, Jamari's Law. I came to know and become friends with Jamari as he worked at a local diner my husband and I visit regularly. I saw Jamari at a minimum once a week. Jamari had a big infectious smile and zest for life that made you happy just by being in his presence. Through our friendship, I became invested in him and the bright future that he had before him, and looked forward to watching him go to college and fulfill his dream of becoming a mechanical engineer. I would see him a few more times after he graduated, and then all of a sudden he was gone. A man who made the decision to drive drunk at a reckless speed killed my friend at just 18 years old. The man received the maximum penalty allowed under Maryland's current criminal law, manslaughter by vehicular or vessel, which, as you've heard, is 10 years. He'll be eligible for parole in 2.5. This maximum penalty is not commiserate of the severity of the crime that was committed against my friend Jamari. The crime committed against Jamari was not a nonviolent accident. It was egregious. Let me state that again. The crime committed against Jamari was egregious. The conduct of Jamari's killer was that of intentionally committing an act that involves knowing the violation of law, such as driving drunk and reckless. The maximum penalty for manslaughter by vehicle or vessel needs to increase so that the punishment in a case like Jamari's actually fits the crime. Increasing the maximum penalty from 10 to 20 years and 30 for a subsequent conviction would provide proper punishment and accountability for manslaughter by vehicle that is egregious, violent, and resulting in death. In addition, it would allow more time for possible rehabilitation, possibly reducing subsequent violations. Mr. Chairperson, Madam Vice Chair, committee members, thank you for hearing my testimony today. The committee's consideration of Jamari's law is very much appreciated.
Thank you very much. There are questions for this panel? Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Is State's Attorney Brave Boy still here with us?
State's Attorney Brave Boy?
My question is.
She's not on the screen as yet.
I'm
Here, she's back. Okay.
I'm here. Yes.
Go ahead.
Were any of the cases that you referenced impaired by recreational cannabis?
I'd have to go and
I'll be glad to see
get that information back to you. I know that some are impaired, but I'm not sure
No,
if
I'm
it was
asking
impaired by
about
cannabis.
had someone to testify on impaired by recreational.
Oh, that wasn't me.
I know it wasn't you, but since you're the authority, I wanted.
Oh, okay. I'm so sorry.
And I also wanted to know, do you have any cases that involve distracted drivers also?
Okay, I'll get that information.
Cell phone usage or such. Thank you very much.
Thank you. Sorry about that. Thank you.
Thank you, Mr. Chair. And thank you all for coming here as witnesses to testify. I guess my question would be involving looking at the court system and discretion of the attorneys, prosecuting state attorneys, discretion. Can you talk a little bit about what discretion y'all have when these cases come before you all, as far as what the minimum and maximum sentencing?
Of course. So for all of what we would colloquially consider the more serious criminal homicide by motor vehicle cases. So you've got gross negligence manslaughter by motor vehicle at the top. That's the most serious. Criminally negligent manslaughter by motor vehicle. And then you've got manslaughter while under the influence or impaired by alcohol or drugs or a combination of the two. And then you've got life-threatening injury by criminal negligence. All of those don't have any minimum sentence. So the minimum sentence is, 0 days, $0 fine, no probation done. The maximum sentence in Jamari's law for the offense we're talking about today is 10 years. So as a prosecutor, as a minister of justice, you are obligated as an ethical matter to consider all the factors you can when thinking about an appropriate resolution to these types of cases. So that is not just sort of retributive punishment for the harm, but also deterrence, the message this would send to the community to deter other drivers, incapacitation, taking this individual who, in the case of a subsequent offense, has demonstrated by their conduct that they can't conform to the requirements of law. Then also rehabilitation. What sentence would give this individual an opportunity to rehabilitate themselves? And I think all of those sort of feed into public safety. We are served by individuals who, when they complete their sentence, when they pay their debt to society, have the tools to succeed and not to reoffend in society. So we consider all of that when we are fashioning a sentence. The challenge specifically with gross negligence manslaughter is that the type of conduct for which criminal liability attaches is so egregious, is so so heinous. You've heard Ms. Graham has testified about a case. We're not just talking about somebody who is impaired by alcohol and collides and kills someone. That is serious. That is criminal. Gross negligence homicide is seeing your friend overdose, getting behind the wheel, using that same substance which you just saw your friend overdose using, and doing that while you're driving in a crowded area. This is conduct that is offensive to the community, offensive to the victims, and requires a serious sentence, particularly when we consider the fact that this is treated as a nonviolent offense for purposes of parole. So courts and prosecutors can take that into consideration and know that an individual, even with a 10-year sentence, is able to secure release after 2.5 years. With ordinary accrual of diminution credits, we're looking at maybe 2/3 of that before they are released as a mandatory matter. We take that into consideration when we're fashioning sentences. And the problem with that 10-year maximum, which translates to an effective 2.5 years, which translates to even sooner that our victims are receiving notice of these parole hearings, is that we don't have the time necessary to put someone on probation afterwards, to make sure that they have an interlock system installed in their car at the penalty of going back to prison for violating their probation, that we don't have the tool necessary to coerce their engagement with substance abuse treatment, to make sure they continue to be safe for the 3 or 5 years after they're released, because the harm they have caused by their conduct is so tremendous that we don't have any room to think about rehabilitation, to put those measures. Because if let's say we suspend it, let's say, like you heard, a guideline sentence is going to indicate 6 months to 4 years. So someone who has engaged in conduct that is extreme and outrageous and has evinced a wanton or reckless disregard for the value of human life, our sentencing guidelines say, okay, anywhere from 6 months to 4 years is an appropriate sentence. Let's say we do top of the guidelines, 4 years. We give them 10 years, suspend down to 4. We put them on supervised probation for 5 years after that. And so they're serving an active 4 years. And if they violate their probation, they can go to prison for 6 years. The problem with that is these cases are complex. They're subtle, they're nuanced. They take a long time to prepare and to go to trial. So by the time you go to trial, 9 months down the line, 10 months down the line, you're sitting across from a victim's family and say, this person's going to plead guilty. We're going to recommend 4 years, which is the top of the guidelines, and they're going to have a parole hearing in 60 days.
May I follow up?
Briefly.
Great. So when you look at the ability of the attorney, a prosecuting attorney, and when we talk about sentencing guidelines, for example, if I was drunk driving, I committed an accident, someone died, but let's say my court date is 10 months down the road, and I went and I got rehab. Would you, the attorney, consider that as part of a plea deal to reduce the sentencing, to reduce the maximum sentencing for that?
Of course, that's something that we all, as part of our jobs, consider. We consider, our obligation is to serve as a minister of justice and to pursue justice. So of course that includes taking into consideration the defendant's history, their approach, the remorse they've shown, the steps they've taken to rehabilitate themselves, the way in which they've taken accountability for themselves. That's of course something we would consider and do consider every day in our courts. And not just in these cases, that's the nature of, being a prosecutor is an awesome in the biblical sense of terrifying.
Right. So more than often the plea deal is offered.
I try personally to reach resolutions in all of my cases.
In general.
I can't speak for every prosecutor, but I think that's fair to say.
Okay, thank you.
Further questions? Seeing none, thank you very much. That concludes the testimony for House Bill 264. And in favor of the legislation, there is one person signed up in opposition to the legislation. Her name is Ann Kirsch. She here? She's coming on virtually. And Kirsch, please, for 2 minutes.
Thank you. I wanted to speak a little bit. I am a parole advocate, so I get cases on the back end of the system. And I also see the escalated parole process that these cases are subject to, which involves 2 commissioners, a victim notification process that can take at least 6 months. These can drag on usually about 8 to 9 months from the time they're sent to the parole commission. So that timeline is a little bit more extended than what I've been hearing. I have also seen some cases where I've had clients who were convicted and had unsuccessful wrongful death suits. So I've seen a wide range, some that were horrific, like the things I've heard today, and I am so sorry for everything that I have heard. And then some cases where there were inconsistencies or things that I've had to present to the commission. So there's just this huge range that we work with. When I'm looking at something like doubling a sentence, I'm looking at a huge investment of almost $60,000 per year per person. As of fiscal year 2022, the DPSCS reported the cost of room, board, and healthcare per inmate was $4,968. So one of the things that I have recommended strongly is to take that money and instead of increasing mass incarceration, to deeply invest it into traffic safety diversions, more alcohol control, things that have been studied and proven effective to reduce these kinds of accidents so that we don't have to have this loss of life in the first place. Because every time that I have to look at something with this type of a loss of life, and I know the harm that it has caused to the families, and I just see the utter destruction across the board. The only thing that I can see is how much more we should be investing in prevention and spending this money on saving lives.
Are there questions for this witness? Hearing none, we thank you very much. In the last panel, Dana Goldsby was supposed to go up and speak. I'm going to ask her to come up right now. Please go ahead.
Good evening. Good afternoon. My name is Dana Goldsby. I am a cousin of Jamari Duckett. Here I have a poster of 4 family members, including Jamari, who were killed by drunk drivers. 3 of my family members, the offenders had committed drunk driving acts prior to killing them. My uncle died in 1968. His offender had a drunk driving incident where they harmed someone twice. Destiny Lyles, student of University of Virginia, starting in her freshman year, got killed on the way to school. Her parents were taking her. And her offender, I believe, harmed someone on the way to killing her. Not knowing that they were going to kill her, but they did harm someone else. Ian Banks, getting off from work at the store, leaving the convenience store where I live at in St. Mary's. Drunk driver killed him. And Jamari, who we're here for today, his offender left back out knowing that he was drunk and killed Jamari. Looking at Jamari's background and history and knowing him as a family member, sweetest, humble guy. And he was taken from us just like that. Just one phone call saying to come to the hospital. Jamari's been in a bad accident. Someone hit him going 90 miles in a 40-mile zone. And to have to look at his mom and my first cousin, which is his dad, John, to make a decision to pull the life support cord and to look at him, head probably 5 times this side, swollen, eyes shut, mouth open, tubes coming out of his mouth, blood stains all over him. Just to look at him and see him disfigured the way he was. And for someone to get a slap on the wrist, basically to come back out and do the same as my other 3 family members happened to them. In order for us to, suppress the pain and get past, I'm asking if you guys could really find it in your hearts. Because it could be your child, it could be you. Any of us can walk out of this door today and someone could be driving under the influence of alcohol, maybe even drugs, and take our lives. And it could be one of us who our family members have to make that decision to not, let us live anymore because we are vegetables in the brain. It's not just about us, it's about all of us in here. Because it's not that you guys are exempt either. It can happen to you, it can happen to me. None of us are exempt from anything that can happen in this world today. And I ask if you can find it in your heart to please put Jamari's law in effect. It's time to turn our pain into purpose and to stand for what's right. Thank you.
Questions? Seeing none, thank you very much. That concludes the testimony for House Bill 264. We're going to go now to House Bill 83 and Delegate Ziegler. And your first panel, please, if any. George Tolley, Chris Figueres, Laura Zoyce, Bruce Plaxton, Elijah Hawk. Delegate Ziegler, please.
Thank you, Mr. Chair, Madam Vice Chair, distinguished members of the committee. For the record, I'm Delegate Natalie Ziegler here with House Bill 83. Also channeling Majority Leader Moon, who brought this bill several years ago, a similar but slightly different bill. I brought this bill last year, you may recall, on behalf of a constituent of mine who lost her husband in the Capitol Gazette mass shooting. But it has broader implications for victims' rights in general. And it's a very simple bill. It would just repeal Maryland's cap on non-economic damages in a wrongful death or grievous injury and allow a jury to decide on reasonable compensation. I want to be clear, this bill has no effect on medical malpractice. As it stands now, the law makes it difficult in many cases for victims to even find a lawyer because the cap is so low. And because it doesn't cap economic damages, i.e. lost wages, it disproportionately discriminates against people who make less money, often women, people of color, the elderly, the disabled. We are one of only 8 states that have this cap. We believe it is unfair and outdated, and respectfully ask for a favorable report on HB 83. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is George Tolley. I'm here on behalf of my law firm, my family, my friends, and everyone else I know who can't be here to testify in favor of House Bill 83 and for the repeal of Section 11108 of the Courts and Judicial Proceedings article. And I want to thank Delegate Ziegler very much for bringing this bill, which is a very, very important bill. We've heard this afternoon about the criminal justice system. This bill concerns the civil justice system, the other side of the judiciary's coin, where we deal with these sorts of catastrophic events that happen and that cause harm. In a civil action, the plaintiff, who is typically the injured survivor of unreasonably unsafe conduct, or the family of a deceased victim, the plaintiff must prove that there was unreasonably unsafe conduct and what the harm is that was caused by that conduct. And the jury decides how much money compensates the victims for the damages they've suffered. So it's not like a criminal case where the judge decides, or at least it should it be. In courtrooms across the country, every day, juries taken from all walks of life, red voters, blue voters, independent voters, rich, poor, journeymen, tradespeople, you have it, housewives, they all come together in a jury room, and they figure out how to value non-economic damages. There is no magic to it. But in Maryland is one of the few states that 40 years ago limited the rights of people in Maryland to get fair compensation by imposing an arbitrary cap on non-economic damages. It was $350,000 back then. It's unfair because it's arbitrary. It applies in every case where there is catastrophic harm, and it is wrong. And this bill asks us to bring Maryland law back into line with 40 other states, many of whom never had a cap to begin with. You will hear no evidence that 4 decades of having the cap has made prices cheaper in Maryland, jobs more plentiful in Maryland, insurance more affordable in Maryland, insurance markets more stable in Maryland. There is no evidence and no public policy reason.
Begin to
for the
wrap up,
cap.
Mr. Tolley.
And that is my last word. I thank you so much for your consideration.
Thank you. Please.
Mr. Chair, Madam Vice Chair, members of the committee. My name is Chris Figueres. I'm here on behalf of the Maryland Association for Justice. So I wanted to start my testimony on talking about what are non-economic damages. This is the portion of a claim or a case where we recognize the injury that you will live with. This is the emotional distress, such as witnessing the death of a child, of your child, the loss of your reproductive abilities, living with burn scars, living with disfigurement, spinal cord injuries, living with amputation of a leg or an arm or other body part. It's the living with. This reflects what makes life worth living. It's the ability to swing a grandchild in a swing, the ability to attend your son's wedding or walk your daughter down the aisle, or to sleep well, to travel, to walk with your family, to move around in an unfamiliar space, and maybe even to testify at a bill hearing. These are injuries that occur to people through no fault of their own. The Maryland law that we have in other places in the code requires that if you contribute to your injuries, you don't have a claim or a suit. These are folks who have not contributed to their injuries they have been through no fault of their own. The cap that is in place in Maryland affects only those that have been in a catastrophic event. Those are the victims. Those are the people that this law affects. And these are the victims that are the focus of this hearing and this bill. So for this reason, and for those that you will hear, we ask that you favorably report on this bill. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. My name is Alicia Hawk, and I'm here to request a favorable report on House Bill 83. I've submitted written testimony and provided citation to the peer-reviewed study by Lucinda Finley on the impact of caps like 11108 on women and children. In fact, Maryland cases are cited in that study, and I've provided some of those in my written testimony. But I want to draw your attention to another peer-reviewed study out of WashU's Journal of Law and Policy, which highlights the disparate impact of damage caps on race as well. Maryland Courts and Judicial Proceedings Code 11-108 devalues the non-economic decisions of jurors and improperly takes from jurors the decision of how to fairly compensate the injured. These studies show that jurors routinely return larger non-economic damage caps for women as opposed to men. And yet by capping the damages, we take away the jurors' power to decide what, on a case-by-case basis, what fairly compensates an injured person. The peer-reviewed research unequivocally shows that not only are the damages devalued, the non-economic damages devalued, but that this devaluing unfairly impacts women, children, the elderly, and minorities. And the reason that is true is because women often suffer injuries that cannot be fully compensated because of the cap. For example, whereas non-economic damages would deal with the pain and suffering and life without perhaps a uterus, we're not talking about high wage earners. You cannot measure a compensation for that type of loss based on the earning potential of a woman or a child.
Good afternoon, everyone. My name is Laura Zois, and I'm a partner at the law firm of Miller and Zois located in Baltimore City. I've been a civil trial lawyer for 29 years. After sitting through the testimony that we've heard today, I think we can all agree that there is probably no more horrific loss or human suffering than the loss of a child. Part of my practice is representing parents of children that have been killed by someone else's reckless conduct. And what I have to do when I introduce myself and talk about the case is I have to tell these parents that Maryland has already decided what their grief looks like, how much they can get in non-economic damages for having their child killed by the recklessness of someone else. As civil lawyers, we don't have a lot of options on how to help grieving families. We can't throw bad guys in jail. We can't require that companies do a better job of hiring safe drivers. We can't force companies to change their policies and procedures. The only thing that we can do is hold corporations and people accountable and get compensation for these families. The other thing we can do is we can try their case. We can have a jury trial, which also brings me to an awkward problem when explaining the issues in Maryland with the family. I have to explain to them that we can put your case on. You can testify as a witness. They'll hear from the experts. They'll hear from the defense. And at the end of the case, the judge will say to the jury, you have to return a verdict that is fully and fairly compensating this family for that loss. What the jury doesn't know is that they're being misled, because what they don't know is that there's actually a cap on the damages that the family can actually hold the defense accountable for. The cap is unfair, it's unjust, and it's not a one-size-fits-all verdict. And so we would ask that you have a favorable report on House Bill 83.
Good afternoon, Madam Vice Chair and members of the committee. It's a privilege for me to testify again in front of this committee. My name is Bruce Plax, and I represent injured people throughout the state of Maryland. And sitting through the bill just before this was painful, because we all go through this every day, where we represent those types of people and try to get them justice, and we are handcuffed because we cannot get them justice for the reasons that Laura just explained. You're going to hear some unfair applications of the cap, how families have been unfairly, justice has been taken away. What you won't hear is one problem that 40 years of this cap has solved. I represented, I'll tell you a story quickly. My office was involved in a case where a young man was quadriplegic. He was paralyzed from the neck down because of terrible gross negligence, where he was electrocuted. And the jury returned a verdict of $18 million for spending the rest of his life as a quadriplegic. And it was reduced at the time to $800,000. I don't think anyone behind me, any of the opponents, will argue that the cap is a fair law. Instead, they're going to argue dollars and cents to you, because that's what I've been hearing on every tort bill for 30 years. We come down here and we're told that the sky will fall if you're fair to victims. If you give them fair compensation, corporations won't be able to operate in Maryland. And that's just not the case. They will tell you about runaway verdicts. There are no runaway verdicts in Maryland because judges have a tool called remittitor. If a verdict is returned where a judge thinks it's an unfair verdict and the verdict is too high, that judge has the power to reduce the verdict. What the judge does not have the power to do in Maryland is to add money to a verdict if the verdict is too low, or to go above the cap. That's why this bill is necessary to provide justice to your constituents and to the people of Maryland. Thank you.
Thank you. Are there any questions? Delegate Kaufman, then Delegate Conaway.
Right. Thank you. This question is for Ms. Figueredo or Mr. Tully, whoever wants to answer. And I have a couple, if that's okay, Madam Vice Chair, I'll be brief. My first question is, when I hear about this bill, they always say, oh, Aaron, the cap increases every year because there's an automatic increase. And so my question is, because I'm sure we're going to hear that from the opponents, because that's what they said when they met with me. So why isn't the automatic increase sufficient? And my other question is, with we often hear that, as Mr. Bruce said, some sort of apocalyptic rhetoric about a lot of businesses are going to close and different things like that happening. So the 40 states that don't have this cap, have there been massive business closures and different things like that?
Thank you very much, Delegate Kaufman, for those questions. There are 40 states. 85% of the American population lives in a jurisdiction without a cap like 11108, and their businesses are open. Those states are economically viable. We're talking about California, Texas, Florida. They're big, successful states that attract a lot of businesses. Maryland would still attract businesses because of the great things that Maryland has going for it. It's a great place to live, work, and raise a family. People want to live in Maryland. They don't want to live in Maryland because it limits their rights. That's actually keeping people away. As far as the cap increasing every year, that is a true statement. It goes up $15,000 a year every October 1st. The problem with the cap going up $15,000 a year, there's kind of twofold. First, it's less than maybe 2% of the cap at this point, of $935,000. So it's a very small amount that it goes up, but it goes up an arbitrary amount every year because it's a decision this body made I think 2 decades ago, almost at this point, to add to a number that this body chose almost 4 decades ago arbitrarily. It doesn't change that the cap is an arbitrary limit on what a jury from the community feels is full and fair compensation under, as Mr. Plaxton mentioned, under the supervision and watchful eye of a trial judge who also heard all of the evidence and circumstances in that individual case. And what fair justice looks like is, in each individual case, what is fair compensation for those damages in that case. So increasing it an arbitrary amount, we argue, is not a solution, not even a Band-Aid.
Thank you, Madam Chair.
Delegate Conway.
Thank you, Madam Chair. Thank you, panel, for coming in to testify. Mr. Tolley, did you just say that the cap goes up by $1,500 per year and it's currently $935,000?
If I said 1,500, I apologize. I meant to say 15,000.
It goes up by 15,000 every year.
15,000 a year, yes. And,
yeah, I'm listening to you.
And for the year of October 1st, 2023 to October 1st, 2024, which is where we are now, I believe the current cap in a personal injury case, like a building collapsing on you or a tractor trailer accident, is $935,000.
Earlier, didn't you use a figure of $350,000?
That was the cap when it was originally enacted 40 years ago. Yes, sir.
40 years ago. When's the last time the cap was raised, not using this $15,000?
About 1995, I believe, is when it was increased to 500,000 and the $15,000 a year was added.
Really?
Yes,
okay,
sir.
Thank you very much.
Delegate Phillips, and then Delegate Taylor.
Good afternoon, and thank you all for bringing this bill. Thank you to the delegate for bringing this bill. Could you edify or inform us on how this actually works in real practice? So you were to get a settlement, you were to get a verdict and it would be the max. How would it work? And if we took the cap off and you were to receive a judgment of $20 million. In states that do not have a cap, how does it then work? What's the reality of how lawyers deal with each other if they feel that the judgment is too high, even without remitter? I just want to make sure we're edified on how this really works.
Practically speaking, I can give you an example of the last trial that I had that got, the judge had to take the verdict away. So the jury found that my client, who was a sexual abuse survivor, they wanted to give her $2 million. They were not informed of the cap at all. But the judge, after the verdict came back and the jury awarded $2 million, the judge had to change the verdict down to what the cap was for the year that she was abused. So they took the $2 million verdict and changed it to $860,000 because that was the year that she was abused. But in other jurisdictions, if you get a $2 million verdict against your healthcare provider that sexually abused you and 7 other people, you get to collect the $2 million and the verdict doesn't get disturbed.
Delegate, I had a case in Prince George's County, a woman who suffered horrific injuries. The orthopedic surgeon that put her leg back together had worked in shock trauma and said it was the worst orthopedic injury he'd ever seen on a leg. And she was put together with hardware, multiple rods, so that she could walk with a walker. And she came into court in Prince George's County, and she was a low earner. So there wasn't much in the way of economic loss. It was all about non-economic loss. And they awarded her about almost $3 million, since she would have difficulty walking the rest of her life. And it was reduced to about $800,000 at the time. And that's how it works in Maryland. In another state, presumably we could collect the $3 million, or it would have settled because there'd be the threat of that higher amount, and there would probably be less litigation because right now defendants can take an opportunity to go to court knowing that no matter what happens, no matter how bad they screw up the case, the cap protects them from the appropriate verdict.
And that's really where I wanted to get, because I wanted to understand in those cases, and if we had a larger verdict, at some point in time, the parties are going to talk to each other about what's realistic. Is that a fair statement?
Yeah, I think so. And I think what really we're talking about is corporate defendants or commercial defendants or trucking companies, because the type of practice that some of us do, I do mostly auto accident cases, the cap is never an issue because we're already capped, because the defendant probably has only purchased $100,000 or $300,000 or $30,000 or $50,000 worth of car insurance. So the car insurance carriers who may come up behind us are already protected. They don't even have to worry about a cap because they've sold $100,000. They've self-limited their exposure, even in the most catastrophic cases, which this law won't help. It still won't help when I have to look at someone with a serious head trauma and explain to them that the drunk driver that hit them, I can only collect $50,000 or $100,000. This law won't help those people. We're still not fixing that problem, which is that people don't buy enough insurance.
Thank you.
Okay, Delegate Taylor, was that it? Did you finish, Delegate Phillips? Okay, Delegate Taylor.
Thank you, Madam Chair. That kind of got to sort of my question, but I'm looking at I'm not an attorney, okay, and I'm looking at the bill, and basically what we've done is we've just taken out all the language in this section of the law, right? But we haven't left any words in there that might give some guardrails around non-economic damages. And I guess that's exactly the point, but it scares me a little bit. So can you speak to that? Why there may not be maybe some language in there that we might leave that would have us have some guardrails around no caps?
I hear what you're saying. So there are two brief answers. The first is that in courtrooms all over the country, as I said, in all the states where there is no cap, there's no language in their statutes about guardrails or any of that. The law is that the jury hears the evidence and returns a verdict, and if the verdict is in the judge's discretion within reason, based on the evidence. It doesn't shock his conscience or whatever the standards are in those jurisdictions. In Maryland, it's if it shocks the trial judge's conscience, then the trial judge can intervene and remit, as Mr. Plaxton explained, and change the verdict on his or her own. At that point, the plaintiff has the option of accepting the new number or having a second trial on damages before a different jury. And depending on the circumstances and what's going on, people will make decisions, and it'll bring people together too, as Delegate Phillips made the point. The second thing I'd say is, as far as, well, no, that's the second thing is the remitted, or the first is that states do this all the time. Juries do this all the time. And you don't have runaway verdicts in the papers in every state in the country where there is no cap. 40 states, as I said, don't have any kind of cap like 11108. And those cases get resolved without controversy and without crisis. The insurance, everyone, all the insurance companies are marketing in those states too. So
just if there was a limit to, I'm sorry, Madam Chair, is it okay if I follow up? If there was a limit to the insurance as a business owner that I carried, then can they come after me? Am I a sole proprietor? Can they then come after me because, I'm the owner of the business? For the rest, for the remainder, like how does that look?
So
me as
if a
business
corporation is the responsible party, then typically the shareholders of the corporation are protected by that business structure from
sole proprietorship.
Different circumstances, and it depends on assets and whether the person is judgment proof, right? Just because the drunk driver only has 50,000 in coverage, if they also own a house or something, then theoretically there could be proceedings beyond the insurance.
Sure.
But those are very rare cases. Most of the time, even a business or the business owners might be judgment proof as a practical matter, because you can seek the protection of the bankruptcy courts. And that happens.
My clients have very little interest in ever going after someone individually, and it's really, really difficult.
Thank you.
Thank you. I just have a couple of quick questions. One question I am going to direct, and just in the interest of time, I'm going to direct it to one person, please, to answer. My first question I'll direct to Mr. Tolley, and that is, what are some of the verdict amounts that you have seen that have gone beyond the cap? That were, by the jury, they were beyond the cap?
Well, we've heard a couple of examples already, and I believe we're going to hear some more examples coming up behind us. But there could be a verdict for $1 million for an individual's lifetime of pain and suffering would be limited by the cap as it exists today. There's a case that will be heard, or that this body heard a number of years ago on a similar bill. An individual was in a Ford truck that had a defect that allowed a fuel-fed fire. He burned over the right half of his body, lost his right arm, right leg. Was a young man at the time, and the jury included $15 million in the verdict for him. At the time, the cap was $500,000 for his lifetime of suffering from burns, and there's really no ongoing medical treatment, so there's no expenses, economic damages in that regard. It's just all the loss of enjoyment of life. There are a couple of cases involving large verdicts for disfiguring injuries or disfiguring treatments for young women who have surgery on their breasts. There's no ongoing treatment. It's all non-economics, and it gets cut to the cap. The examples are plentiful, and they happen all the time.
Okay, well, that was my second question, so I'm going to direct that to you as well. And I wanted to know, is this something that occurs all the time? And you're saying that it does. And does it occur all the time in the sense that we're talking millions and millions that, the jury wants to award and there is the cap? Or are those $1 million cases, are they a little bit, like I'll say in the 3+ million, are they few and far between, 3 to 15 million, 15 to 20? I'm just trying to get a range here.
So I'm not aware of any really good data to answer your question about how many cases are worth that much money
Okay,
because all we would have access to are what the verdicts are, and there's really no good reporter of verdict information in
Okay.
Maryland. So I'm
Okay.
afraid I don't have a good answer for that one, other than to say anecdotally, every lawyer in this table and many of the lawyers I know, we regularly are explaining the cap to our clients.
okay. And my last question is I'm gonna, and again, I want to direct it to one person just in the interest of time. I'm gonna direct this to Mr. Plaxton. What are some of our neighboring states? Are some of our neighboring states some of those 40 states that have been mentioned? And if we do have some of our neighboring states, just how close are our neighbors, such as Delaware? You know, what are some of the states that do not have a cap?
So I think it's in our position paper, the list of states that have similar caps, but my understanding is there's not a single state on the eastern seaboard from Maine to Florida other than Maryland. That Delaware, the corporate capital of America, has no caps, no contributory negligence, has dram shop laws. Maryland has one of the harshest tort systems in the country.
Okay, great.
But it's in the material, and it's few and far between. And if I could add on to, and I know you wanted to limit it to one person, to Mr. Tolley's answer to the previous question on verdicts and data. One of the problems with that is it will be skewed, because if I have a death case of a non-economic earner, and even if there is unlimited insurance, they're going to call me up and write a check for whatever the cap is, the 900,000. So you're never going to hear about a $3 or $4 or $5 million verdict for the family. You're going to hear about, that they paid the cap voluntarily, or they paid close to the cap because they know all our clients can get is the cap. So then they want a discount for not having to go to court. So the data is going to be skewed in Maryland because these cases don't get tried sometimes.
Gotcha. So then you just led me to my next question then. I wasn't going to ask it, but I'm going to go ahead and ask it. Would not having a cap lead to faster settlements so that the plaintiffs could get quicker remedy?
I think it would lead to faster settlements. When there's there's the carrot or the stick, and if the stick is that you have to go in front of a jury and explain your egregious conduct, then you would think that carriers would be more inclined to settle these horrific cases.
Okay, great. Thank you. That concludes the this panel. We have a second panel.
Madam
Just a
Vice Chair.
question? Oh, I'm sorry.
Madam Vice Chair, may
Yes.
I just quickly interject? I have a list here. DC, Delaware, West Virginia, Pennsylvania, and Virginia do
Okay,
not have
thank you,
caps.
Delegate. And actually, we have one more question. I'm sorry, I didn't. Okay, we have a few more questions. Don't go anywhere. Stay right there. So Delegate Tomlinson. Oh, okay, Delegate Tomlinson.
Thank you, Madam Vice Chair. So close, we were almost done.
Sorry.
I can't remember who mentioned earlier, but somebody had mentioned earlier that in other states, this hasn't resulted in insurance costs going up. Can you talk a little bit more about how this will or will not affect additional liability exposure for kind of all lines of insurance? And I just ask this because we see, we hear a lot about insurance premiums and out-of-pocket costs going up. So can you talk a little bit more about that?
So the costs of insurance in Maryland, I don't believe there's any evidence, and I've looked over the last 40 years that says that the cap has any real effect on insurance premiums or the cost of getting a policy for $30,000 or $50,000 or whatever for your car insurance, or the cost of $1 million policy for a business. Insurance isn't cheaper in Maryland because of 11108. In some jurisdictions like Florida or I think there's a couple other jurisdictions where the courts have declared a cap like 11108 unconstitutional. In those instances, the cap is repealed judicially in a day. We're giving everyone notice until October 1st in this bill. So there's plenty of time to prepare for whatever might happen if something were going to happen, which nothing will. When a court declares a cap unconstitutional, it's gone. And there's no report anywhere in any state that has ever repealed a cap that the insurance market crashed or that prices went sky high or that the sky fell. So the evidence is that repealing a cap like this does not, in the experience of any state where this has happened, does not result in the kind of crisis that you'll hear people say, oh, this is going to be terrible. We're going to lose our, whatever we're going to lose.
Delegate, keep in mind that the people that this committee seems to be most concerned about are the people who can barely afford insurance. So these are the people purchasing $30,000 policies or $50,000 policies. Whether their exposure is $900,000 or $1 million or now unlimited, it doesn't change the risk to the insurance carrier that's selling a $30,000 or $50,000 policy. In other words, it should be the same. That rate can't go up. You're talking about maybe the Lloyd's of London policies or something that could be affected by this. And again, there's no data that even those policies are ever affected by any increased risk.
Thank you.
Now, seeing no further questions, that ends this panel. Let's move on to our second panel. We have Patrice Clark and David Horak, Monica Murphy, Doug Murphy or Douglas Murphy, Michael Winkleman, I have 8 for this panel. Let's try to see, you want to try to see if we can get 8 or yes, let's go ahead and try to see. We can just move around. Robert Leonard and Aaron Van Ross is going to be on Zoom. Okay, so it's actually 7 and Kelly Donahue. Great, looks like we have everybody and Ms. Clark, if you want to start.
Thank you so much. Good afternoon, Madam Vice Chair and members of the committee. My name is Patrice Meredith Clark, and while I am a trial lawyer and an officer of the Maryland Association for Justice, I am here today on my own behalf and on behalf of my family. I want to tell you a personal story that illustrates the way that Maryland's cap on non-economic damages harms Maryland citizens and helps foreign corporations. On May 4th of 2019, a 2-person helicopter crashed into the Chesapeake Bay, killing 2 young men. The passenger, Matthew Clark, was my brother-in-law. Matt died, leaving my sister-in-law to care for my niece, who was 5 at the time, and my 2 nephews, who were 8 and 11. My family hired an excellent Maryland attorney to investigate the cause of the crash, and eventually we learned that the engine installed on the helicopter was defective. The engine was manufactured in Pennsylvania by a Pennsylvania company called Avco, which is the parent company of Lycoming. Even though the crash occurred in Maryland, the engine was designed and manufactured by a Pennsylvania company in Pennsylvania, and so suit was filed against Lycoming Avco in Pennsylvania federal court. The reason I want to tell you this story today is because Avco has argued in that case that is still pending that the non-economic damages cap in Maryland should apply, even though, or should limit the recovery for Matt's widow and her children. Matt was 36 years old, by the way, and so was the pilot, who also had a child and a pregnant wife at the time. And that's because Pennsylvania doesn't have a cap on non-economic damages. So a Pennsylvania company wants to use so a Pennsylvania company that designed and manufactured a defective engine in Pennsylvania wants to use Maryland's law against Maryland citizens. Corporations from other states should not be allowed to cause the death of Maryland citizens and then be shielded from adequately compensating those citizens. For these reasons, I urge a favorable report on House Bill 83. Thank you very much.
Thank you, Ms. Clark. Ms. Murphy, are you ready to go now? Okay, sure.
I'll speak on behalf of the Murphys.
Okay,
My name
great.
is David Herrick. I am here primarily on behalf of them, but on behalf of dozens of other catastrophically injured people I've represented. During the first conversation I have with them, I have to tell them, I'm sorry. The value of your loved one is what the legislature has already determined it to be without hearing any of the facts about you, about them, about the accident, about the tragedy. We already know what it's worth in advance. And in this particular case, after detailing everything that you heard before to the insurance company, I found out something amazing. The crackhead driver was driving a commercial vehicle for a company that had paid premiums for $5 million of coverage. And the adjuster, who was out of state after receiving my information, called me and said, we have $5 million of coverage. I can't believe that you have a draconian, unfair law in Maryland that limits our ability or your client's ability to get paid whatever a jury determines the amount of their damages. Your client's case is worth every penny of the $5 million of coverage that my client bought. But I'm really sorry. I can't give you that because we have shareholders, and our shareholders are not going to allow us to pay out claims where the law doesn't allow you to get the amount of money in coverage we have. So here we had a business that protected itself. One would say the insurance companies stole from them because they bought a policy they couldn't even tap into. They wanted to do the right thing. They wanted to protect people that their employees got injured and killed. And the law that we have in our progressive state prevented them from doing so. And so at the end of the day, I'm so glad that I didn't tell the story before me, or I'd have been crying too, as many of you saw me crying earlier. At the end of the day, these two people whose lives were forever changed by a ridiculous law got $53 a day. Does anyone think in this room that they wouldn't pay $53 a day for Matthew back? That's our law. It needs to be changed.
Thank you, Madam Vice Chair. My name is Robbie Leonard, and I am a principal attorney of Leonard & McCliggett Law Group. Unlike a lot of my colleagues who are here today, I'm a general practice attorney. So on a given day, I might handle a divorce case, an adult guardianship, criminal defense, but I also handle personal injury, wrongful death cases. You're going to hear from remote testimony from one of my clients, Aaron Van Rens, who will be testifying here today about lifelong injuries that he sustained from a tragic accident from October of this past year on Route 70 in Frederick. Now, for Aaron, it should be the residents and citizens of Frederick County who listen to the facts of his case about his life and give a verdict that's just for him. It should not be reduced by a judge arbitrarily afterward based on this one law. Now, it truly is a miracle that he's here today to testify. And even bigger miracle that the driver behind him had a dash cam where we could see what happened, because the truck driver who ran him off the road just kept driving like it never happened. That dash camera video told us the story. Now, in many of the verdicts that I've had over the years, I've represented many lead-poisoned children in Baltimore City. There were some cases where a jury came back and said, you get $0 in non-economic damages, because based on the facts of that case and that individual, that's what the jury believed was just. Now, I didn't like it, but that's what the outcome was. But there were other cases where I did get beyond that cap on damages based on the individual facts of that case, but unfortunately, it was reduced. Just to tell you about one case that I had, a young lady who was lead poisoned in Baltimore as a child. And because she was a child, the cap on damages was $350,000 at the time. When we first tried the case, a jury returned a verdict in March of 2014, non-economic damages of $534,000 had to be reduced. We tried the case again on damages only. The second time in November of 2014, a jury awarded a verdict of $700,000 in non-economic damages, had to be reduced. Based on appeals, fast forward to March of 2019, she got a jury verdict in non-economic damages of $2,030,000. Once again, reduced. Almost 10 years into litigation, we finally settled her case. Unfortunately, within this arbitrary cap on non-economic damages, I ask you to find a favorable report so that young lady, folks like Aaron and my other clients can get damages based on the facts of their case. Thank you.
Thank you. Ms. Donahue?
Madam Chair, I'm happy to go, but Mr. Leonard's client is on the screen. I don't know if you want to have him go after Mr. Leonard or if you'd like me to go.
Well, that's fine. We tend to just do, talk to in person first and then do virtual, but that's fine. Is that Aaron?
Yes, Your Honor.
Yes, sure. He can go first, online. If that's not gonna, okay, great. So, Aaron Von Rhines.
Oh, sorry, grabbing a sip of water. My name is Aaron Van Rens, and I was the driver of the car involved in a serious accident on Interstate 70 between Hagerstown and Frederick on October 13th of 2023 while returning from college for a midterm break. I was struck by a tractor trailer and forced off the road and through the median near Myersville and into oncoming traffic. As a result of multiple rollovers and impact with an oncoming vehicle, I received extremely serious injuries and was transported to the trauma center at Meritus Medical Center in Hagerstown. Once stabilized and moved from ICU, I underwent orthopedic surgery to reconstruct my right shoulder and spent weeks with my left arm immobilized and my right leg in a brace for a broken knee. The injuries I have suffered as a result of the negligence of another driver have left me facing a lifetime of chronic pain and impairment. Some of these difficulties are obvious that I face. For instance, most athletic pursuits are no longer an option for me. I used to be an avid figure skater, but now the possibility of aggravating and any existing injuries means that this is no longer feasible. Any sleeping has become extremely difficult because the nature of my shoulder injuries are such that without specific and proper support for my shoulders, they can easily dislocate and cause excruciating pain. There are other kinds of impairment and indignity that no one considers until it happens to them. It's now possible to shower with concern, it's not possible to shower without covering the surgical scar on my right shoulder, as the nerve damage makes both touch and variations of temperature severely painful. Any structured clothing must now be retailored because my left shoulder is shorter and at a higher angle than it's supposed to be. I can no longer wear a backpack because my shoulders cannot bear anything above half a pound, meaning that I am required to use a roller bag to get things like my laptop and books across campus. There are things that will affect me for the rest of my life in significant fundamental ways. I cannot pursue any jobs that require me to stand for long periods of time or to lift heavy things or anything else in quick succession. Long distance driving is not possible except in the direst of emergencies, as it causes a lot of discomfort in my knee, and improper support for my shoulders can lead to severe pain and loss of capacity throughout the rest of the day. The reason why I'm testifying remotely is because I go to college in Winchester, Virginia, and driving to and from Annapolis would have meant spending the rest of the week recovering, impacting my classes and academic work. There is no way to fix injuries of the kind that I have suffered. Even the best care leaves scars, loss of function, and a lifetime of chronic pain. Our legal system makes remedy for that by way of awarding victims for fair monetary compensation instead. That compensation is supposed to take into account the pain, impairment, and loss of dignity and enjoyment that the accident victims will suffer over a lifetime. While it's difficult to quantify these things, our system has determined that a jury should make the final determination when the parties involved cannot reach an agreeable settlement. It's unfair for the state to override the will of the jury in considering the value of that compensation. And it's even more unfair when considering that if an accident occurs over a state border, no such artificial limitation applies. I ask you to vote favorable on HB 80083 and to help ensure future accident victims more fair and just compensation.
Thank you. So now we'll go to Ms. Donahue.
Okay. Thank you, Madam Chair. Ladies and gentlemen of the committee, my name is Kelly Donahue. I am here on behalf of myself, my law firm, my family, my friends, and my clients who can't be here. When I was driving into town today, I saw this amazing mural painted on the side of the building right on Church Circle. And it's Ruth Bader Ginsburg and Thurgood Marshall. And the words imprinted on the mural are equal justice under the law. And the vision of this great country and those Supreme Court giants were that all people are equal and should be treated equally by the law. But that's not what's happening in Maryland because of the imposition of caps in the civil justice system. Study after study, even reported by the University of Baltimore, are that non-economic damage caps promote and endorse discrimination against women, children, the elderly, and persons of color. Caps tell these groups of people that we are valued less than others. So the opposition is going to tell you that caps are going to destroy the economy. The sky is going to fall. This is a false statement. If you look at the comptroller's most recent report describing Maryland's economy, what you will see is no mention whatsoever of caps. Caps are irrelevant to the economy. If caps were a driver of a robust economy, then after 40 years of 110108 in Maryland, every other state in the country would be doing it. And guess what? They're not. So the analysis is simple. We need to ask ourselves when voting this bill, do we want to be a state that promotes discrimination and unequal treatment of kids, women, and persons of color? And these are not my words, and I don't mean that to be such a flippant, easy statement. These are the words, the very words spoken by elected officials on the U.S. Senate floor and in the U.S. House Judiciary Committee when they rejected caps on non-economic losses. They specifically said caps on non-economic damages discriminate against men, women, children, and minorities. So we have to ask ourselves, do we want to walk the walk, and do we want to embody the principle that's on that mural that we see every day when we come into Annapolis? Equal justice for all, equal justice for this family, or do we want to say that Mr. and Mrs. Murray's child is worth $53 a day? Because that's not equal justice. Thank you so much for your time, and I ask for a favorable vote on House Bill 83.
Thank you. Are there any questions? Delegate Conaway.
Thank you, panel, for coming in to testify. To the lady that just testified, you named several groups that would be covered potentially under the discrimination. So what groups of people would not be included in those groups in existence, I guess, that would be covered, would be
White men.
white men. But now
And
with the
listen,
white men,
I'm
no, I
married
didn't
to a
say
white
that.
man.
I
I
didn't
think
say-
they're
I'm
great,
just-
but
I
that's
didn't-
just
I didn't say
reality.
that. So my question is, are you saying that the white men would be subject to the same caps as, let's say, maybe the black men?
Yeah, so the cap is the same.
No,
but
I
here,
just asked that question. All I'm asking is, would the white man be subject to the same cap that the black man would be subject to? That's all I want to know.
they are subject to the same cap, but there's a reason why there's a discriminatory impact.
Well, that's your opinion. Thank you. And that's their opinion. Thank you.
Thank you. And members, I forgot Mr. Winkleman, and I want to make sure that he has a chance to provide his testimony, and some of you may have questions for him.
Good afternoon, Madam Vice Chair. My name is Mike Winkleman. I'm an attorney in Prince George's County who represents individuals who are seriously harmed in tort actions. I come before you not only as an attorney, but also as a husband, father, and citizen of our state who cares deeply about equal justice for all under the law. Maryland law does not provide equal justice for all in tort cases. Instead, Maryland law discriminates overtly and significantly against people on the wrong side of the wealth gap and against the most vulnerable members of our state. Our current law improperly creates a tiered system of justice which compensates people based on their economic status rather than the extent of their injury. I'm testifying remotely as I hope to have several clients here with me today. Unfortunately, they are not able to be here, so I will relay their stories to you. The first is a young woman in Prince George's County, a recent college graduate who nearly lost her arm in a motor vehicle accident. She was taken to shock trauma, and although they were able to save her arm, she lost almost all use and function of her arm for the remainder of her life. Statistically, this is another 60 years. Based upon the cap, she will receive only about $13,000 a year for loss of use of her arm for the remainder of her life. The second woman is someone who I presently represent who lost her husband of 42 years as a result of someone else's negligence. He was not working, so her entire claim is based on pain and suffering. One of the questions she asked me was, how do I put a value on the loss of my husband of 42 years? And I told her, you do not put a value on the loss of your husband. I do not put a value on the loss of your husband. A jury will not put a value on the loss of your husband. The value of your husband has been predetermined by the date of her death. As an attorney and counselor, it is heartbreaking to tell this to clients. I therefore ask for a favorable report on this bill.
Thank you, Mr. Winkleman. Are there any questions? I have one question, and this is from Ms. Donahue. My concern is that I believe one of the reasons why the caps are discriminatory to women and people of color is because of the actuary system. So for instance, a Black woman's age, whatever, life expectancy is not as long or predicted to be as long as someone else. So my question to you is, how would extending or not having a cap change that problem that we already have systematically in our, that exist?
So that's a great question. And it's kind of a long answer. So I'm going to sort of try to keep it abbreviated. I'm happy. I know. And so I lead in with that, and I'd love to come by to your office and we can sit and chat, because I think there's a lot of layers to answer that question. But the fact of the matter is, white men tend to be, because of decades of baked in discrimination, they earn higher wages in the marketplace. So if you take a white man, their claim for wages is not capped. And so they may have lost an arm or a leg, and they go to trial, and let's say they get, $1 million in pain and suffering damages, but they make a good income. So maybe they get another $1 million in lost wages. Well, you take the same individual, the woman you're talking about, and let's say not only is she an African-American woman, but she's also a stay-at-home mom. Well, she goes to court, and her job, and I'll tell you, I'm the mom of 3 kids, that's a hard job, but she doesn't get paid for that job. So she doesn't get to make a lost wage claim. So the only claim she gets to make is for the disfigurement of having lost the same arm and the same leg as the white man who's the high wage earner. So the jury gives her $1 million for her pain and suffering, but the jury can't give her $1 million for her wages. Let's say the jury gives her $2 million for her pain and suffering, because not only does she not have an arm and a leg, but she can't sit on the floor and build Legos with her kids anymore. She's never going to be able to do a first dance with her son at his wedding. Well, she got a $2 million verdict. Hers was just all pain and suffering. The man, he gets $1 million for his pain and suffering. He gets $1 million for his wages. If the cap's $1 million, depending on what year it is, he gets to collect his whole $2 million. But mom, because her job is an extremely important one, but one in which no wages in the eyes of the law attaches, guess what? Her $2 million gets cut by 50%. She gets $1 million. That's why there is report after report after report from peer-reviewed studies across the nation that discrimination is baked into caps, because we can try as we want to bridge the gap and bring in equal pay for equal work, but we're not there yet. And that's just the reality. So now not only are we saying you don't get paid the same in the workplace, but we're also saying the loss of your leg is worth less than the loss of his leg. That's just kind of how it works in reality.
Okay, fair enough. Delegate Conaway.
Thank you very much again for coming in to testify. So you were talking about lost wages, and then you spoke about one person not having any wages, like a stay-at-home mom, and another person, they do have the lost wages. That is an actual loss, isn't it?
I think the point
One is a damage and one is an actual loss, isn't it?
they're both damages under.
So therefore, you're saying that if you don't work, you should get paid. Like if I work, but if something happens to me, I should get the same pay that Mark Zuckerberg should get?
No.
Oh, okay. Thank you.
No.
That's all. I was just trying to be clear. I didn't understand.
All right. That concludes all questions for this panel. Thank you very much for testimony.
Thank you so much.
Yeah. Okay, I still have 2 more individuals listed. I have Mr. Andrew Betterman, as well as Gwen Marie Davis. Are you here? Gwen Marie Davis? Okay, and is Mr. Bedman?
He signed up wrong, he's written only, oral today.
Okay, great. Thanks for that clarification. So that concludes everyone who is favorable with respect to House Bill 83. Now I'm going to call up the unfavorable witnesses. That first, Carrie Silverman, Robert Eaton. I just saw him go out. Oh, there he is. Okay. Carville Collins and Bryson Popham. Did we get everyone? Yep. And in whatever order you wish to begin, feel free to start.
Good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to testify today. My name is Carrie Silverman. I'm an attorney in Maryland, and I'm here on behalf of the American Tort Reform Association. We oppose the elimination of the statutory cap on non-economic damages. In my practice, I closely follow trends in litigation across the country. And to start off by and speak on that today, and to start off by stating the obvious, no amount of money can compensate adequately a lifelong injury or the loss of a loved one. But yet, jurors are given the very difficult task of essentially quantifying the unquantifiable. They're given no guidance, and they struggle with that, understandably. There is one place that they do get guidance, and the one place they get guidance is from the plaintiff's lawyer. When the plaintiff's lawyer does their summation, they ask for an amount. And what we've seen in recent years is that plaintiffs' lawyers are increasingly asking for higher and higher levels of non-economic damages. Uncoincidentally, what we've seen is a rise in the size and the frequency of verdicts overall, personal injury and wrongful death verdicts. And I think that's because, lawyers are asking for more money, 20 million, 50 million, 80 million for a person's non-economic damages. Sometimes they'll put in a different way, 4 million, 1 million a year, or maybe $5,000 an hour. However it's put, it comes out to that extraordinary amount. And they're sometimes asking jurors to send a message with non-economic damages. Keep in mind, punitive damages of the purpose of them is to punish and to deter, and they're uncapped in Maryland. And we also have economic damages, which are uncapped and apply for anything that's quantifiable. If we eliminate the guardrails, what we end up with is a system where jurors will look to that. There will be nothing in place to stop excessive awards that we're seeing elsewhere in the country, and there will be consequences to that I can explain in more detail if you'd like.
Thank you, Madam Vice Chair and members of the committee. My name is Carville Collins. I'm an attorney representing Maryland Employers for Civil Justice Reform, which is comprised of many of the largest employers, businesses, and healthcare providers in Maryland. We're here in opposition to House Bill 83 for the reason that caps on non-economic damages have been a vitally important public policy in Maryland for more than 37 years. In 1985, a severe crisis in availability and affordability of liability insurance occurred here in Maryland. The response was the creation of two task forces to study this issue carefully. There was an executive branch and a legislative branch task force. They both worked together, and some of their findings included, first, the current availability, and again, this was back in 1985, the current availability and affordability crisis in certain lines of liability insurance is not a manufactured crisis. The civil justice system can no longer afford unlimited awards for pain and suffering. I also quote, a cap on allowable pain and suffering awards will help reduce the incidence of unrealistically high liability awards, yet at the same time protect the right of the injured party to recover the full amount of economic loss, including all lost wages and medical expenses, end of quote. On the strength of these study findings, this committee helped craft the 1986 legislative solution to the crisis. In light of this well-studied foundation for the current caps on non-economic damages, why ever would the General Assembly want to risk inviting back an insurance crisis by removing these caps? One other provision that was mentioned by the proponents is that remittitor would somehow be a cure or a safeguard. And Madam Chair, if I may just respond very briefly to that. From the case law in Maryland, we know the standard for remittitor is profoundly high, and thus the incidence of remittitor is extremely rare, as noted by practicing attorneys across Maryland. The Supreme Court of Maryland has held that remittitor generally relates to a trial court's evaluation of the amount of the jury's verdict in relation to the evidence that the jury heard. And that is whether the verdict is grossly excessive or shocks the conscience of the trial judge. Now, the notion that remittitor with this very high threshold would serve as a readily available safeguard or cure for excessive verdicts has no basis, in fact, under established Maryland law and law practice. Thank you.
Thank you, Madam Chairman, members of the committee. Robert Enton on behalf of the American Property Casualty Insurers Association. Our trade association represents roughly 60% of the property and casualty insurance companies in the state of Maryland, and we are strongly opposed to this legislation. Let me just make it really simple for you all. Well, you have two types of damages. You have economic damages, and then you have non-economic damages, also known as damages for pain and suffering. Well, why do we have a cap on one and not the other? There is no cap on economic damages. Why is that? Because it's measurable, because evidence can be presented to a judge or a jury that can measure those damages. And the reason we have a cap on non-economic damages, quote, pain and suffering, is because how in the world do you measure that? The number could be off the chart. Sympathy for the plaintiff, maybe the great job that the plaintiff's lawyers did, but no limit whatsoever and no way to quantify at all what those damages might be. If we go back and we look at what the current law is, the current cap is roughly $1 million for non-economic damages. And it goes up by $15,000 a year every single year, regardless of the rate of inflation and regardless of anything else. And that seems to work. You know, right now there's tremendous pressure on insurance rates right now. How many of you have gotten calls from constituents? How many of you have gotten your bills for insurance and the rates are going up? Do you think for 1 second, that your rates will not go up in the state of Maryland once this becomes law and once non-economic damages are off the chart? And believe me, and I'll wrap up, Madam Chairman, what this is going to do is place tremendous pressure on the insurance companies to settle the claims that they have. Particularly, you know, right now, let's say we're liable if we fail to settle in bad faith. And what's going to happen if this bill passes is there's going to be pressure for us to say, you know what, Delegate Cardin, we're going to offer the $500,000 or whatever the number is of policy limit that you have. We're going to offer it, but you're going to be responsible for that unlimited excess personally. And perhaps you'll have a claim against your insurance company then, and we're going to feel that pressure because we didn't settle within your policy limits because you wouldn't let us. So we just think this is a bad bill. We think you ought to give it an unfavorable report. Thank you very much.
Thank you, Madam Chair, members of the committee. Pardon me, Bryson Popham, appearing on behalf of the Maryland Association of Mutual Insurance Companies, which is a relatively small association, a dozen or so companies of relatively small insurers, half of which are domiciled here in Maryland, all of which do business here in Maryland. They sell automobile, homeowners, and general liability insurance to your constituents in every one of your districts. We also appear in opposition to this bill, And I want to talk about something that hasn't been mentioned today, and that's reinsurance. The reason my small clients are able to do their jobs for your constituents is that they don't have limits on the insurance that they offer in Maryland. They are able to buy reinsurance. That's insurance for insurance companies. Every insurance company has to buy it. Companies like my clients depend on it more heavily. And what it does is create a stable, healthy insurance market. If we were to pass this bill, I'm not saying that the market would disappear. I am saying that the reinsurance market would take a really hard look at Maryland, having had a cap on non-economic damages for the last 40 years. And by the way, I was here in the mid-'80s when that first passed. And the term we used at the time in the insurance industry was capacity crunch. The crises Mr. Collins referred to were real. They could come back. One of our members came into being by your predecessors, created by the legislature back in the 70s because of just such a crisis. So don't make any mistake about the seriousness of what you're being asked to do here. It is serious. We have a stable, healthy market. Is it perfect? No. But you come back here every year, and guess what? You have changed this cap many times over the year. You can do that every January when you return to Annapolis, and that's what you should do. Thank you, Madam Chair.
Thank you. Delegate Erican and then Delegate Kaufman.
Thank you, Madam Chair. Thank you all for being here. So I've heard sort of the consensus is if we pass this, then insurance rates are going to sort of essentially punish everybody to try and help a small amount of people. But I've been trying to see if there was any real good data that backs this up. So first, if anybody has that data showing that that's the truth of the matter, I'd love to get my eyes on it. I've yet to see something like that. But I do have here a quote that I'd ask whoever wants to respond to can. This is from Victor Schwartz. In '99, he was the general counsel for the American Tort Reform Association. And to the Business Insurance Journal, he wrote, "Many tort reform advocates do not contend that restricting litigation will lower insurance rates. I've never said that in 30 years, end quote." So if anybody would like to respond to that, I'd love to hear it.
I'll give it a shot. If I understand you correctly, and please correct me if this is not right, the quote from Mr. Schwartz was that he did not say that it would lower insurance rates. We're not saying that any insurance rates are going to be lowered. My testimony, at least, would be that the system that we have established over the last 40 years has created stability and predictability, and that's what we need. It's not a matter of lowering rates. In fact, I would characterize it not so much as affordability, but availability. That's the key.
Okay, so it wouldn't cause our rates to go up as was testified, before you, but it would actually cause.
I don't know the answer to that, Delegate. I'm
Okay.
sorry. I don't want to represent that would be accurate because I
Okay.
don't know.
So the real fear is that the market would just implode. And have you seen that in any other places? Has that occurred?
We have seen market disruptions, I will call them.
Okay.
Not only elsewhere, but in Maryland. One of my clients for whom I am not appearing today, but is a small insurance company domiciled in Maryland. I've been on their board of directors since 1989 when they were created. They do business in Maryland, Pennsylvania, Virginia, and they were in Florida. They left Florida precisely because of the tort liability environment down there.
Okay, and if you know this just more broadly, and if you don't, you can certainly get it to me later. Does the insurance market still exist in Florida?
I'm sorry?
Does the market still exist? I mean, you've given me one.
As far as I
anecdotal-
know, yes. I think it's problematic, I would say.
Okay, all right, thank you very much.
Delegate Kaufman.
Yes, if it's okay, Madam Chair, I have two questions. And then I know the ranking member has a question, so I'll try and be brief. Mr. Collins, is it?
Yes, Delegate.
Okay, thanks. So my first question is, am I not correct that there are certain ways, forgetting the cap or not, that insurers can can already automatically lower their liability. For example, in malpractice cases, they can do a high-low with a patient. So it says, if you win, I'll give you, I'll give you a max of $1 million. If you lose, I'll still give you 500,000. And that way, many times the doc or the other party is not out of money. So is it true that there are other ways besides the cap or they say, we'll settle with you so we can avoid, paying, $300 an hour or $500 an hour for a lawyer for a 2-week trial? So are there other ways that insurers, like high-lows and settling cases, that people can lower the insurers can lower their costs?
Delegate, I'll defer to the representatives of the insurance industry, but let me suggest this to you. There are other ways that these cases get resolved. I think one of the important ways was touched on by Mr. Enton is that, there are other damages in these cases. You had 14 witnesses who were in support of the bill come before you, and only one of them happened to mention the availability of economic damages. None of them mentioned the availability of punitive damages in Maryland. Both of those types of damages are unlimited. There is no cap on economic damages. There is no cap on punitive damages. So the overall recoveries of these cases, which are essentially what gets resolved, whether they are decided by a jury, a judge, or in a settlement, all of those types of damages are available to resolve the claim and resolve the dispute. As to the specific measures that an insurance company would take and offer or not offer, I'd have to defer to my colleagues.
Okay, and my second question for you is this, and that is, you said that the cap is essential. And Delegate Ziegler articulated already that there are very few states on the East Coast that have this cap. So if it's so essential, why do you believe that so few states have the cap? And so that's my other question. Then I have one final one, and that'll be that.
Yes, thank you, Delegate. I think every state has a different set of circumstances and a set of conditions. And in Maryland, going back to 1985, I was here also. And it was exactly as Mr. Popham has described. It was a crisis of availability and a crisis in affordability of liability insurance. That condition brought about a very careful study by this committee, by task forces in both branches of government, executive and legislative. And the decision for Maryland was, well, under the circumstances that we faced, and after a full year of careful study by these investigatory bodies, the best solution that the General Assembly could develop was this system of caps. And eventually, over time, that system has been refined and increased. The caps have been increased first by a set amount, and then with the addition of the $15,000 per year escalator. So that was the solution that was formulated for Maryland, for its market, for its conditions. And it continues to be a successful decision made way back then. We can still see the effects of it today. I can't tell you what other states have or have not faced in the way of their insurance availability and affordability. But for Maryland, this was the solution that was crafted, and it has worked well to provide stability, affordability, and availability of insurance.
Well, thank you for the history lesson. I wasn't even born in 1985, so that was a long time ago. My last question is for Mr. Enton. Mr. Enton, I sense your anxiety and I sympathize with anxiety because I'm an anxious person myself. But beyond your anxiety and the fact that you're a gifted orator, do you have actually evidence that things are going to be as catastrophic, like studies you can share, that things are going to be as catastrophic as you suggest in your testimony?
Let me just say that there's probably no industry in the state of Maryland that's more regulated than the insurance industry. You go and grab the insurance article from the back shelf there, and you'll see the level of regulation that occurs. We are very, very limited in our ability to raise rates, and we're limited in our ability to set rates. And the basis for us, what do you think that the basis is for us setting your insurance rate? It's based on the claim experience that we've had in the past year. And when you get that increase, it's going to reflect two things. It's going to reflect the cost of the claims more than anything else. And as the cost of claims goes up, premiums go up. And that's the basis. We have to have an actuarially sound basis for setting our insurance rates. And if someone thinks they're not actuarially sound and they're not based on experience and they're not based on evidence, they can challenge those rates. But that's what we do. That's how we set them. We can't just arbitrarily pick a rate and say, now, from now on, you're going to pay, this amount. Last year, you only paid that amount, but now you're going to pay this amount. That's what our new rates are. They're subject to very, very intense review to make sure that they're actuarially sound, they're not unfair, they're not discriminatory. So that's how we set rates. And if you think for 1 minute that lifting this cap is not going to increase insurance rates, then that's just not reality.
I appreciate your passion, Mr. Enton. Thank you for your indulgence, Madam Chair.
Thank you, Delegate Taylor, and then Delegate Munoz.
Thank you, Madam Chair. As a business owner, if my expenses go up, then my prices go up. So there's probably the answer to that question. But another question is, I've heard here that the cap disproportionately affects those with lower incomes. So economic damages are calculated based on wage potential. Is that right?
No, it's based on lost wages, and you can figure that. Okay, if I'm 30 years old and I'm no longer going to have a job,
right?
And I could have worked till I was 70, and I could have made X number of dollars during that time. That's an economic loss. If my car was destroyed or my house was destroyed, it's a measurable loss, and that is totally, completely unlimited. There is no cap on that. The only thing there's a cap on is something that you really can't measure.
There's no cap, but if I am a home healthcare worker making $15 an hour, it's sort of tied to my ability to earn wages in the future, right? Based upon what I'm making now. And so, but if I am the business owner, making $100,000 a year potentially, my ability to earn wages in the future is higher. So my non-economic damages then would be higher. So I'm just making sure that that distinction is made, because then it is kind of true that lower income folks are disproportionately.
If I could just add to his response, there's more to it than lost wages. I mean, lost wages are a type of economic damages, and for some people that may be a substantial part of their economic damages. But of course, there's also part of economic damages are past and future medical expenses. If it was a horrible injury, there's going to be, life care expenses that could be in the tens of millions of dollars, covering everything from, help in the home to whatever it could be.
A list of
anything that's quantifiable can be put in that bucket. And if when there's a cap on non-economic damages, or in states where we're seeing there's a cap on punitive damages, what you'll see is pressure to move the sought amounts to the areas that damages are available. So there are ways of putting as much as possible. A plaintiff lawyer can put as much as possible into that economic bucket. If let's say it's a person who wasn't working and they had children, maybe now they're going to need to have a home aid to assist them during that. Maybe they're going to need to have care for their children, to get them around places.
Oh, that's
Um,
factored in.
all of that can be, if it's quantifiable, that you're gonna need this, you could, because you can't do it anymore yourself, but you're gonna need to hire help or have expenses. Those can all be quantified and those could all be
Got it. And then
recovered.
just one last question, Madam Chair. Are your lawyers' fees included in that? So when you're, I mean, I really don't know. I know it may be a crazy question, but are your fees that you pay to your attorney included in your non-economic damages?
If you are referring to the attorney's fees for the company that is representing the defendant that's been hired by the insurance company, those costs are part of the insurance cost. They are incurred by the carrier. Is that the question you
I'm
had?
not suing the insurance company for these non-economic
But
damages.
typically what happens is a suit is brought and an insurance company may offer a defense. It's called a duty to defend, and they provide defense counsel and they incur the cost. If I understand your
Yeah,
question.
but I'm talking about me bringing the claim.
Oh,
Do
okay.
I
No,
have-
no, that's
Typ-
on
I
you.
mean, typically, the plaintiff's person, their attorney's fees are through a contingency fee arrangements with their attorney. And those are usually a percentage of the recovery. That percentage is uncapped. It's typically maybe 30%. If a case goes to trial, it might be 40%. It could be more. But that is the way typically, attorney's fees are paid in our system.
If I could just add one point to that typically in the state of Maryland, when someone comes to you for a personal injury case, you're going to enter into an agreement to represent them. And normally it's going to be a third of whatever the settlement is. And if it goes to trial, then it's going to be 40%. So if you're going to remove this cap, which is currently at $1 million, okay, then you got to figure that the attorneys that are representing the plaintiffs, their compensation is also going to be unlimited and without any cap whatsoever, and will represent almost half of what the damages are.
Thank you.
Delegate Munoz.
Thank you, Madam Chair. Thank you, gentlemen, for indulging us. I know that this has been a really long discussion and the committee has a very long evening ahead of us still. But I just want to clarify, because with this particular bill, while our hearts obviously go out to all the victims that we've heard from, this is not a situation where we actually need to have so many hypotheticals, because you've experienced this before. And like my colleague mentioned, a handful of us here on this committee were not alive when this happened in 1985, and even more in the General Assembly in general, were not alive when this happened previously. So just for clarity's sake, I've heard that insurance rates, last time you sort of dealt with this, insurance rates went up. Physicians did not want to practice medicine because it adjacently affected them. And even diving boards were removed from swimming pools for children because there were concerns about liability. And so are there any other broad ranging implications that would cause financial insecurity, lifestyle changes for Marylanders that you saw previously that we would expect to happen again if we were to reverse course on this decision?
Delegate, let me start. This report is the report of the governor's task force to study liability insurance, chaired by Joe Curran, who at that time was the Lieutenant Governor of Maryland, December 1985. It documents all kinds of circumstances and situations that you have asked about. I'm happy to provide a copy of this to the committee. These are the things that were discovered and documented and vetted by this task force of experts back in 1985, leading them to their recommendation, leading this committee and this General Assembly to their conclusion that a legislative solution was needed.
Okay. And so to avoid the unintended consequences we've sort of hypothetically been talking about, all we need to do is to look to that.
This would be one source. This would be one source of those kinds of circumstances. Maybe the insurance industry can be more specific as to situations.
With respect to your reference to insurance, I would simply urge you and your colleagues on the committee to think of two things: affordability and availability. They are equally important. They didn't get fully covered in this hearing today, but they're both very, very important components.
We have a robust and competitive insurance market in the state of Maryland right now. And one of the factors that has caused that to occur is the regulation in this arena to not have unlimited amounts of money that have to be paid out.
I would just add quickly that Maryland is known for having a reasonable, stable civil justice system, which can factor in to business decisions as to where to locate or how to operate. And we don't have here in Maryland, I'm happy to say, we don't have the types of astronomical awards that we're seeing continually in places like New York, Pennsylvania, Georgia, Florida, for example, that don't have these kinds of limits on damages. And I think it's hard to quantify and say, well, that brought in how many businesses, I can't say. But I do think it is a factor for folks who are operating businesses or thinking about it in Maryland.
I appreciate it. Financial insecurity for Marylanders is definitely something we want to avoid. So thank you guys very much.
Delegate Cardin.
Thank you, Madam Chair. Just two quick questions. Mr. Collins, first of all, thank you all very much for your testimony, and your reputations precede you, both good and bad, but it's a very esteemed panel. So, Mr. Collins, first of all, there was a mention, I don't know if it was you or somebody else, but I think you'd be the appropriate person to answer this, that juries could be asked to send a message by sending back high verdicts. And my question is, isn't that, or couldn't that be grounds for a mistrial? You're not allowed to do that. And if you could respond to that, that'd be number one. And then to Mr. Popham, who spoke about reinsurance, maybe we could talk offline a little bit about it because I want to learn a little bit more about this. But are you suggesting that we could lose the ability to get reinsurance from some of these national and international companies because of this? Because isn't reinsurance vital to make sure that the insurance industry?
Which of us do you want to respond first?
Madam,
We'll go in order.
Was the question for each person?
It was just one question for each.
Yeah.
Okay.
Let's go in order, Delegate, and I'm happy to step forward with your first question. Juries will do what juries will do. There is a check that the trial judge does apply. And so I think it was Mr. Plaxton who suggested that check, that safeguard, that solution would be remittitor. And what we are saying is that is an extremely rare situation in the trial courts of Maryland. Yes, it's on the books. Yes, it's available. But the Court of Appeals and now the Supreme Court has said over and over again that it is a very, very high threshold. In other words, trial judges give great deference to decisions of the jury in almost all situations. And it would only be if it reached the very high level of a verdict being grossly excessive or shocking the conscience of the trial judge. That's a pretty high bar. So the notion that remittitor with this very high threshold would serve as some sort of a readily available safeguard or cure for an excessive verdict award from a jury, that simply has no basis under Maryland case law or the actual practice of law, except in the most rare and exceptional circumstance.
I'll follow up later. I don't understand why you wouldn't reserve for an appeal for a potential mistrial if in fact the idea, the concept from the plaintiff or the plaintiff's attorney is to try and use this as an example, as opposed to litigating the case at hand for the purposes of the case at hand. It seems like if you are not doing it that way, if you're going through doing it for other reasons, that you are setting yourself up for major complications for that lawyer.
If I can maybe respond, I mean, it is a basis for a mistrial, and I've seen companies make those cases, and I've seen plaintiffs' lawyers make those arguments over and over again. It has to reach a level of egregious misconduct for a court to take, the extraordinary step of requiring a retrial. And if a case was, it's not likely to happen is what it comes down to. You just don't, you don't see that unless there are other errors that have fulfilled, throughout the trial to get to somewhere where a court is going to say, you said, send the message. This is a case where punitive damages because of misconduct wasn't at that level required. This is a bare negligence claim. You shouldn't have been arguing to send the message that we're going to throw this out. It has to be compounded with other things.
And Delegate Cardin, with respect to your question about reinsurance, I make this offer to you and all the members of this committee. I'm happy to sit down with you anytime you wish and have a discussion about that. It is a not well-known element of this discussion, but it's critically important, especially to small carriers like the ones I am representing today. So I'm happy to have that discussion with you. I don't think we have the time to do it in this. Thank you.
Delegate Conway.
Chair, thank you. Thank you, panel, for coming in to testify. Does anyone know when the last time the non-economic cap base was increased here in Maryland? The base.
Yes, Delegate, I know that. In 1994, the cap was raised from the $350,000 level, which was set in 1986. It was raised to $500,000. And at the same time of that adjustment from 350 to 500,000, there was the annual escalator was also added 15,000 per year.
Okay, and when was the last time this type of bill was introduced here in the House of Delegates?
I can actually comment on that. There have been, by my count, at least a dozen legislative proposals, either identical to this bill or similar, dealing with either this cap, the one on general tort actions, or also other types of tort actions. And of those dozen or so legislative proposals that date back to the mid 2000s, around the 2005, 6, 7 timeframe, each and every session since that time, those bills have failed here.
Those bills have, well, I did something on the torts claim cap. So
yes,
what I'm trying to get to is when was the last time this identical concept was introduced here? And then I was going to ask you, why do you think it didn't pass?
So you are right. The local Local Tort Claims Act, there have been some adjustments to the cap that this committee and this legislature has made over the years. This bill does not address the Local Tort Claims Act.
No.
If you'll recall, these are private actions, not actions brought against governmental entities. Why do I think these bills have failed consistently over the years? I truly think, even though it may have predated some of the members of the committee, legislators remember the crisis and they do not want to revisit it.
Thank you so very much.
Thank you, panel. Thank you, members, for a robust discussion. That concludes the testimony for House Bill 83. Now we're going to bring up Delegate Stewart, who has been patiently waiting. Welcome to Judiciary, Delegate Stewart. I'm here testimony for House Bill 392. And we have a panel here of Marceline White, Cleveland Horton, Nashana Kress, and Jonathan Smith.
Thank you.
Is that everyone we have? Do we have everyone here? Does Jonathan Smith come up?
Yes.
Okay, great.
I think we're good. Okay, cool. Oh. Looks like we're.
Okay, Delegate, whenever you're ready.
Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, I'm Delegate Von Stewart, and this is House Bill 392. So I'm not going to shock anyone's mind or blow anyone's mind right now by saying that housing discrimination based on various protected classes remains an issue. This is not just an issue that we read in the history books from the 60s, 70s, 80s, or 90s. It's still happening. A small minority, not most, but a small minority of realtors and mortgage servicers and landlords continue to do things like deny leases or evict tenants or steer homeowners based on the way people look. That's still happening. And the best tool we have in our arsenal to deal with this remains the Fair Housing Act, which since the early 90s has been a tool to hold people accountable for letting discrimination bias the housing market. And the best way to prove housing discrimination under the Fair Housing Act is by recording conversations with housing providers. In other words, if you catch someone not leasing to someone, not lending to someone, steering someone based on their race or gender or national origin or what have you, and you catch that recorded, that's going to be really, really valuable, dispositive, probative evidence in a court of law. Fair housing testers are a group of people who try to prove that fair housing testing violations have occurred, oftentimes by posing as housing applicants looking for homes, apartments, etc. In Maryland, we have an all-party consent law, as y'all know. We're one of 11 states with an all-party consent law. The vast majority of states have a one-party consent law. These all-party consent laws unintentionally allow discriminatory housing providers to get away with discrimination because we can't record them in Maryland without their consent, and therefore fair housing testers can't do their job very well. This bill creates a narrow exception to Maryland's all-party consent law. It would allow one-party consent just for trained fair housing testers employed by either the government or a vetted nonprofit organization. Sometimes recording is good, not only because it adds context. Sometimes these statements made by housing providers are so outrageous that you need a recorded conversation for the judge and jury to really believe it. And also, discriminatory actors can be coded. They can use coded or subtle language that you need the recording to really figure out what's going on. This not only protects applicants, it also protects housing providers because fair housing testers themselves are recorded. We can make sure that they're not violating guidelines themselves and that they're abiding by the law as well when they're testing. I'll just briefly say with my 20 seconds left, I want to be clear. This is number one, this is civil law. This is not criminal conduct. So we're not talking about probable cause. Number two, we're talking about recording calls when the person is part of the call. We're not talking about the wire. We're not talking about wiretaps of conversations between two people and a third party. Finally, this bill is fundamentally constitutional. Courts, including the Supreme Court, have repeatedly approved the use of testing. HUD, the OAG's office, people do this all the time. It's not a violation of the Fourth Amendment. I'm happy to talk more about that case law. But for now, I appreciate y'all's time and urge a favorable report.
Good evening and welcome back, Chair, Madam Vice Chair, members of the committee. My name is Cleveland Horton. I have the pleasure and privilege of serving as the Deputy Director for the Maryland Commission on Civil Rights. I am here today on behalf of the Commission to show our support for HB 392. Housing plays a crucial role in providing stability, security, and a foundation for our communities. Also near and dear to your hearts, housing indicates who you all as legislators do and do not represent. Simply put, housing is a fundamental pillar of our society. But for many, fair housing has never been fair in the areas of application and enforcement. However, our great state here in Maryland has made great strides in the enforcement of our fair housing laws. House Bill 392 gives agencies like ours and others another tool in our enforcement tool belt. We all know that fair housing law is only as valuable as the enforcement mechanisms put in place to assist agencies like ours in holding individuals and entities accountable to these laws. Through increased enforcement, we can accomplish a number of positive outcomes, which include ensuring that individuals are not denied housing opportunities based on a protected class, contribute to the creation of diverse and inclusive communities, reduce social disparities, safeguard vulnerable communities, and support economic empowerment by providing everyone with an equal chance to secure housing. Supporting the allowance for fair housing testers in Maryland to utilize recording and performing their test will enhance transparency, uncover discrimination, and strengthen our efforts to ensure equal housing opportunities for all. For these reasons, the Maryland Commission on Civil Rights urges a favorable vote on House Bill 392. Thank you for your time and consideration.
Good afternoon. I'm Jonathan Smith. I'm the Chief of the Civil Rights Division of the Office of the Attorney General. I want to start by thanking this committee for supporting the creation of my office last session. I've been on the job since January 1st. So you've had a long afternoon, so I'm going to try to summarize a few points. You've got my written testimony, and I just want to, the delegate testimony mirrored what I wanted to say in exactly the same order. So I'm just going to emphasize a few points. I felt like I thought he was looking at my notes. This is a very narrow exception to the two-party consent rule. And this is a strategy that has been effective for a very long time. And it's an important strategy. The ability to record the test and be able to play it and use it as evidence in court is a very powerful tool to ensure that our fair housing laws, not just the Federal Fair Housing Act, but the fair housing laws of the state of Maryland are protected. I have litigated cases using testers and have litigated cases where you had strong testing evidence that came from that recording. It removes all doubt about what was said and removes the dispute about what was said. It leaves, it provides for the court and for the parties the opportunity for an early resolution of the matters. The HUD has been using housing testers since the enactment of and funds most of the housing testers across the country since the enactment of the Fair Housing Act. And the Department of Justice has been doing this for the last 30 years in states where it is permitted to record in all of those states. This is a very, very pedestrian and common practice that has led to the most effective opportunity for advocates to ensure that the ability to get a home, that fundamental thing that we all need, that is foundational to almost everything else that we do, to be able to get that in a fair way. And so the final thing I'd say is we're going to use testers in the work that we do. And the only question is whether the evidence that they're going to have comes in through their testimony or is going to come through their testimony being recorded.
Good evening, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works on economic rights, equity, and housing justice through research, education, and advocacy. We're here in strong support of HB 392. Just to make a few brief points. What we're asking to do is to create a narrow exception to strengthen fair housing enforcement across the state. This is what 39 other states already do. This is what the Department of Justice already does in Maryland today. This is what HUD recommends as best practices across the country for fair housing testers. What we're talking about is not wiretapping. We're talking about pressing play on your iPhone when you ask if someone is using when you're asking if someone uses vouchers, so you can ensure that the law you passed a few years ago to protect voucher holders is being enforced and no one is violating that law. That's what we're talking about. And then you're turning it off. You're talking about not wiretapping. This is not private conversations. This is commercial conversations because you're talking about renting property. So this is not protected speech. And it's an efficient allocation of resources. This is federal money and state money that is flowing to fair housing organizations. And it allows us to use that money more efficiently rather than employing 2 to 3 people. You can employ 1 by using this recording. It is a better use of resources. It protects the property owner to make sure there's no bias on behalf of the tester and there's no false memory or confusion of memory. And it protects the tester to make sure you're getting exactly what someone said and how they said it. So it also makes sure that sometimes now discrimination is not as overt. It's a little less clear. And so you get the best possible evidence, which helps everyone in terms of rooting out discrimination. For all these reasons, we ask for a favorable report. Thank you.
Thank you, Mr. Chair. Thank you guys for being here. So I have a couple questions. The first one is that you had mentioned that federal HUD testers are already doing this in Maryland. So
Department of Justice.
Okay, so who would this bill be for then? If they're already doing it with Maryland's all party recording laws, then what is this for?
Yeah, so lots of people are doing testing.
Okay.
Without the recording. And so you've got, there's a funding stream that comes through HUD for testing that goes to organizations. I think you're funded.
We're one. Okay, so it's like a private.
They're
Okay.
private, but also the Department of Justice in the Civil Rights Division, the housing section does testing. They will not record in states where it is prohibited.
Okay, so they're
currently-
not,
Currently
okay,
in Maryland, in the 39 states where it's permitted, they'll do fair housing testing and they'll record.
gotcha. I
in
was
the
about to say
states where
how
it's not
cute that they
permitted.
don't have to
Right,
follow our
Right,
rules.
exactly. They,
How nice for them.
yeah,
Yeah,
exactly. No, 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 no.
I think I was talking too quickly. Sorry.
That's fine. I just
Yeah.
want to make sure I understood it. My other one was, why can we not get a subpoena? So if we think somebody's violating this, why can we not go to a judge? It's because it's not criminal?
Yeah, I mean, if you're talking about like probable cause or a warrant, that would be like in the criminal context. This is a
Okay,
civil
so
case.
there's no opportunity for us to get some evidence in front of a judge or a magistrate and say, look, we think these guys are violating this housing policy. Can we get permission to record? Like what we do with sort of like underage alcohol sales, things like that. So because it's just not criminal, there's no avenue for us to get that kind
I'd
of
say two
access.
things from my perspective, and there are other people, I'm not a lawyer, so I'll let lawyers answer the legal part of it.
They
but-
look confused too.
No, I can answer this.
Yeah, I was like, I'll let-
That's just how I look, Elliot. Yeah.
That's just
That's just my face, yeah.
Yeah, I'll let lawyers.
fine. It's
answer
better
the
than mine, which is
legal
usually-
part of it. But we do handle things that are complaint driven, where we have a hotline and people call us and say, someone discriminated against me, and that will trigger us to investigate that property, for example.
Yeah.
But we also do what's called systemic testing,
Okay.
where you want to kind of spot check places.
Yeah.
And a lot of times now people don't always realize they're being discriminated against, again, because it is subtle. So
Right.
it may be something where until you do the testing, people don't know because they didn't get called back as quickly, or they didn't get the same level of information, or
Right.
someone gave one person, 25 documents and the other person one.
Right.
And so we want to do both kinds of testing, and you couldn't get a subpoena for the
Right.
systemic testing.
Okay. That I think that
Yeah.
answers my question, I think.
Okay.
Yeah.
I mean, I don't want to belabor it, and I know it's been a long day. The idea about when you need a warrant comes out of the Fourth Amendment, when there's reasonable, when you have reasonable expectation in the privacy of the conversation.
Right.
When you're a landlord and someone calls you up and says, I want to rent an apartment from you, you have no reasonable expectation of privacy in that conversation, first of all. Second of all, it arises in the criminal context, and these are all civil enforcements. The only criminal statute around fair housing statute, it goes to or addresses where there's the threat of force or force used to prevent someone from exercising their fair housing rights.
Okay.
That just doesn't come up in
Right.
this
So
context.
in that
Yeah.
situation, you could get a
Yeah, you could
warrant,
get a
but-
warrant, right.
Okay, I
Right.
understood. I actually had a girlfriend who was a tester. Very interesting.
Thank you, Ms. Chair. Thank you all very much for coming and for your compelling testimony. First question is there any other area where we try and eliminate the two-party consent anywhere in all in law except, well, we just spoke about in a criminal context, when you get probable cause, you can get a warrant from a judge. Is there anywhere else? Question number two, should I do them all, Mr. Chair, real quick? Okay.
So there's a law enforcement exception to Maryland's one-party consent law. So for example, if a police officer, they can record you. If they have some suspicion that there's criminal conduct, they don't need to go out and get probable cause or get a warrant. They can record you. And in fact, this is partially tied up in our body camera law too, because body cameras are not always apparent. And officers don't always have to say that they're recording because there's a law enforcement exception to the all-party consent rule.
Okay, so the only exception we have that we can talk about is the law enforcement exception. Is that fair to say?
Yeah, as far as I know, that's the only exception.
Number two, you talked about 39 other states allow for this type of program. How many of them have a two-party consent that they eliminate?
39 states have all-party consent laws. So 100% of the 39 states that allow this have all-party consent laws.
They do.
Yes.
So they are not the one party. None of them are one-party consent.
Correct. 11 states in the union, including Maryland, have one-party consent laws, wherein fair housing testers cannot record. Is that right? So, sorry, I flipped it. Oh, man. Words are hard. Like ENT only works till 5. I don't know what you guys do. I mean, this is like asking a lot of me. Okay. So 11 states have all party consent laws, including Maryland, and therefore fair housing testers cannot record. 39 states have one party consent laws and they can record.
So of the 39 states, none of them are two-party consent that you created. the
Correct.
exception.
Exactly.
So
Exactly.
none of them have done this.
Correct. None of
Okay.
them have done that, but all of them have a much broader statute than this proposes.
But some of them have been changing that over time. There were states that had similar laws to us and have changed those over time. And in fact, this kind of legislation is being introduced in California right now. And I think Illinois and a few other places that have laws like ours.
In other words, some of the 39 use the bill in front of you as a stepping stone to become a one-party consent state. So this would not be unprecedented. This would not be the first state to pass this, but we would be the only state with it currently in law, because some states just went, once they kind of dipped their toe in the water, they just kind of went all the way in.
Got it. To the Mr. OAG or Assistant OAG, I just want to be clear. There's no criminal context to this application. In the testimony across the hall, if I remember from the little bits and pieces that I tried to watch, there was some sort of admit or suggestion that this had a criminal context.
There was a suggestion, and I went back and confirmed, and I actually, after leaving that, because I was other than the threat statute or the force and threat statute, I was unaware of any criminal context in which you could enforce the fair housing laws. I went back and looked at that statute. That's a Civil War era statute that was enacted in the wake of the Civil War that addresses any interference with someone exercising a civil right. That's the only context. So the only way, and I've never heard of this, and I think it's beyond sort of abstraction. This would come into play is if a tester were to call up a housing provider and they say, well, if person of this demographic characteristic applies, I'm going to beat them up or I'm going to shoot them or something. I mean, it's sort of out of the box rare, but that's the only fair housing criminal context in which this comes up. So it's sort of, I guess in some sense, theoretically possible, but it's theoretical also to sort of such a vanishingly small point that it would never come up.
All right, and final question, Ms. White, you had mentioned that you get compensated, I think, through the federal government. Is that how you get?
We get compensated. HUD money flows to county governments, and we get funding through county and city governments.
And do you get funding based on the number of violations that you do? How does it work?
It's contractual, so the contracts differ by the county or city, so they're negotiated. So they differ, frankly, depending on what we negotiate with each county or city government.
I just want to.
But it's not based on violation. I mean, it's not
commission based.
No, it's not commission based.
Okay, I just want to make sure.
No, that would be
problematic.
No.
Okay, thank you.
Can I just add to that as well? So as a state civil rights agency, we also get funding through the federal government. That money comes in through HUD to our agency as well. We have the opportunity to take a look at trending issues and partner with agencies such as Economic Action in Maryland and Equal Rights Center to offer them fees. We'll offer them funding to perform tests for our agency. They perform the tests, they provide us with the information, and we do the investigation and move forward with the litigation for those cases that we find cause for discriminatory activity.
Thank you, Mr. Chair. So this committee's stuck in a 3-year debate over wiretap laws, and we can't move a single bill. So I just wanted to preface my questions with that. We've talked a lot about this issue, and the expectation being a two-party consent state is that people pretty much feel that they have a right to privacy no matter what the context is. So in these kind of civil cases, if you're an enforcement agent, you could still, and you suspect there's still some broad issue, bigger provider, a lot of infractions, you could still get a warrant. You could still get some kind of monitoring. You could still surveil the situation if you like. Shouldn't there be some evidence that one of these folks has to get before they frankly just get unilateral wiretap evidence? or wiretap authority?
Yeah, so it's a great question, Delegate. So we absolutely have to balance competing interests here, right? This is something that this committee has to do all the time. And on the one hand, you do have some expectation of privacy in the conversations that you have. And what Supreme Court precedent has suggested is that in some contexts, you have a really heavy expectation of privacy in your own bedroom, for example, in your own home with your spouse. That's the maximum. And for the government to overcome that, they need a really strong showing, right? Especially a really strong showing of, for example, criminal conduct. And I know you know this as sort of our resident civil libertarian in the House of Delegates. I know that I'm preaching to the choir here, but I'll still nevertheless, I'll still proceed. I'll still proceed and suggest that in this context that we're talking about, oftentimes in an office building, a mortgage servicer, a Bank of America branch, a landlord leasing office, or where these conversations generally happen, in public areas or where they generally happen, you're talking about commercial speech. You're talking about things that people are saying publicly to housing applicants who they don't know, who they do not have a pre-existing private relationship with. And in those situations, the Supreme Court has held, whether we agree or not, the Supreme Court has held that there is a very, very low or non-existent expectation of privacy. And that's why the Supreme Court, I can give you some, I was very anxious to do this earlier, so I appreciate the opportunity. You can look at cases like Havens Realty Corporation versus Coleman, Northside Realty Associates versus United States versus Fountain Blue Apartments LP, which is 2008. Happy to provide these with the committee. This issue about constitutionality is open and shut. It's fundamentally constitutional to do this. But to your question, should we, right? Should we provide a little bit more? And we have to weigh, on the one hand, people's right to be free from discrimination in the housing market with how much privacy we think that commercial actors should have. And I think that we should err, I'm essentially putting this bill forward, think that we should err on the side of eradicating discrimination in the housing market, because commercial speech just is not very protected under law. Now, to your point, though, we're talking a lot of times, like when we're talking about Marceline's organization, these are private actors. So number one, they're not, as you know, even held to the Fourth Amendment, because we're talking, that's state action. But number two, they can't go get a warrant. This is a nonprofit civil rights organization. They can't go get a warrant. And in a lot of cases, we're not talking about probable cause and warrants, because we're talking about huge civil cases. These are civil enforcement cases. We're not talking about the criminal context. So it would not only be onerous from just sort of a practicality, as Ms. White said earlier, with, you know, the way that this testing happens, but it would also be impossible in a lot of cases to get civil warrants. It would clog up the courts. I'm not even sure it's possible. And certainly in the case of nonprofit organizations, it is literally impossible. You're not talking about government action.
Could I just make one very small point on this? The expectation of privacy is in the conversation itself, not in how you capture the conversation. It is clear that when you do testing, and we're going to do testing, and this is going to happen in the state, the question is, what is the evidence of what was said during that conversation? It's not whether the conversation was captured. It's whether it was captured in the memory of the tester and in their notes, and will be admitted into court through testimony, or whether it's captured on a recording and it'll be admitted through the playing of that recording. That conversation is just as private or not private, whether or not the tester is reporting on what they heard versus playing the recording of what they heard. So the expectation of privacy ordinarily goes to the question about whether it's admissible. It is admissible. One way or another, it's going to come in. The question is, do you get the best evidence to bring it in?
Talking about is in the mind of the tester, is that admissible? What I'm talking about, we're talking about here, is if we record a private conversation, we have, a government agent record a conversation. Does the cases that you have talked about affirm that concept?
Yes.
Yes.
Yes. There's a series of cases, they're cited in my testimony, we can provide more, where the court has permitted, and this mostly comes up in the criminal context, they permitted for example, found that there's no Fourth Amendment violation for a undercover agent or someone who's been paid to record a phone call by police in the context of policing. Maryland, there's one case that took up this question under our wiretapping law, said that federal law and the federal constitution does not permit the admissibility of this evidence. The only limitation on the admissibility comes under the provisions of the Maryland statute that goes to the admissibility of recorded evidence. And so the only limitation is not in the Constitution, federal Constitution, the Federal Omnibus Crime Control Act, in the Maryland Constitution, but it's found in this law. So that's the only sort of limitation on the use of the recording.
10-4. Nonprofits cannot get a warrant. But last year we created under the Attorney General's office, the Office of Civil Rights, which provides the authority to investigate these issues. That authority does have the authority to get a warrant. Am I correct there?
So we have, under the statute, we have the authority to issue a subpoena and compel testimony. The statute doesn't expressly speak to our ability to get a warrant. And I would have to give more thought to what the limitations are. Maryland, the authority of the Attorney General in Maryland is governed entirely by what this body gives it. So I'd have to go determine whether there was any authority elsewhere. It's not in the statute that created the Civil Rights Authority.
Does the Attorney General broadly have the authority to get a warrant?
I don't know the answer to that question.
And that's kind of what I'm getting at here is we create this great big authority for this specific purpose. Now we kind of want to broaden the wiretap to let nonprofits record what most people perceive to be a private conversation. It gets to be a little police statey. Do testers get compensated for this work?
They do.
Okay. Can you speak to that a little bit?
Sure. So there's a HUD guidebook in terms of compliance. And I think you'll hear from another panel later about some of the compliance that we go through. But testers are screened and they're trained, and you go through a pre-screening, and then you do a 3-hour training, and then you do another 3-hour training, and you work with somebody who's done testing before. So you are trained alongside someone to do your initial round of testing a couple times. And part of what you're tested on is your ability to basically do note taking and be able to write comprehensively, and your memory, because you are relying right now on your ability to recall because of our testing. You know, you're not just having a recorded conversation. So we're relying on your ability of how well do you recall what just happened at the event. But it is a paid job.
Okay. All right. I appreciate the dialogue.
Yeah, and if Delegate Granberry, I could just quickly, I actually think the status quo is the police state. Because to me, if I was a housing provider, if I was a landlord or mortgage servicer, I would be terrified of a situation, someone coming, I think that they're leasing an apartment, I utter something that maybe I shouldn't have. Now I'm being dragged to court based on the recollection, and maybe the context that I said it or the tone of my voice, I didn't mean it that way at all. And now there's a federal case against me. To me, that's a terrifying police state. To me, that's a 1984 situation, which we have in 11 states, but not in 39 states. I think having a record of that both protects housing providers from, testers saying, oh, this is what they said, I promise, I wrote it down. And it also protects housing applicants to make sure we don't still have discrimination. To me, I think what we have now is the scarier situation. I think having actual physical recordings that judges and juries can listen to frees us from a totalitarian state.
It's the best evidence for everybody because you can hear it.
I don't know if I agree, but you make a really good pitch. So thank you. Thank you so much.
Yes, I'll be brief because we have about 5 bills left. But my point is, my question is, Delegate Stewart, is one of the purposes of the testing checking for ADA violations, Americans with Disabilities Act violations? And how do you think, if so, how do you think that your bill, if enacted, would improve testing for ADA violations?
The answer is yes. ADA violations have been and continue to be subject to fair housing testing. And I think it could improve the situation markedly, because imagine right now, if you have someone who has disabilities that goes in and says, hey, I want to rent this apartment, and the landlord's thinking, oh, maybe it's a small home, maybe they're not totally ADA compliant, they should have put in some elevators, they didn't, there should have been a ramp, they didn't put it in, and they think, oh, if I let this person with disabilities, they're in a wheelchair, they need some assistance to walk around. If I rent to them, they're going to figure out that I'm not ADA compliant, and then I'm going to be in a real mess. I'm going to have to pay a lot of money. That's obviously illegal and discriminatory conduct to not rent to someone for that basis. But how are we going to prove that the decision was done in that way, other than the memory of the tester? If we actually have a recording of the landlord being like, oh, honestly, I'm not sure this is really the right building for you, given your, physical limitations. It's one thing to have someone remember that conversation happened. It's another for the landlord in their own words for their recording to be played in the court. I think, it's just much more powerful and probative evidence. So I do think that this bill would be a powerful step for protecting people with disabilities.
Thank you, and thank you for staying past 5.
Thank you, Mr. Chairman. Thank you, panel, for coming in. Delegate, respectfully speaking, I really like your bill, but I do have some questions. I hope the chair.
Respectfully speaking, I love questions. I'm not sure if everyone else loves them. I've had enough coffee, so.
So would political discrimination be a problem?
No, political party affiliation or ideological persuasion is not a protected class in Maryland or in the United States.
Great. And before the person presses play, why can't they just ask the renter, say, listen, I'm going to record this conversation.
Yeah,
this conversation is being recorded.
Yeah, they could, but I don't know very many racist landlords who would then start uttering their racist stuff at that point, right? I feel like
I can't say right to that. I don't know.
Well, that's, I mean, some people.
I disagree with that, but let me talk about something I do know something about. So you're introducing this bill to breach the wiretapping laws based on the police body camera. The first is that
No. What I was saying is that it's an analogous situation. It's more analogous to a police body camera that's not visible than it is.
Exactly. That's what I wanted to get to right there.
Yeah.
How did you figure that out?
Well,
because that's my baby, the police body cameras.
Yeah.
And we had to do something very, very, very special for that. So that you might not historically know the ins and outs of the police body camera.
I can guarantee you, Delegate, that I do not historically know the ins and outs of body cameras. I can guarantee you. I can guarantee you that.
Thank you very much.
Yeah.
I'm sorry to add, but I just want to make sure you have the chance to touch on the amendment that we were provided.
Yes, I appreciate that. Thank you, Delegate. So we are going to clarify, Delegate Cardin, I think deserves a lot of credit for actually watching the Senate here. And I can't say that I do that for all the crossfire bills that come to ENT. But I think things, as Delegate Cardin mentioned, and was some of the panelists talked about, got a little bit confused in the Senate about exactly what we were talking about. And so what the amendments make clear is we're not talking about wiretaps. We're talking about recording of a conversation that includes and I think that part of that confusion in the Senate was our fault as the bill sponsors. It wasn't all, the opponents sort of bringing those things up in a scurrilous way. So we were just basically cleaning up the language around both, making sure that we're not talking about criminal conduct, making sure we're not talking about wiretapping. And I'm forgetting any other amendment?
No.
Okay. All right. Thanks.
Delegate Stewart.
That's Delegate Schmidt.
I was about to say. He's part of the Stewart dynasty. We still claim him.
Just making sure my name tag was correct there for a second. It was. Thank you, Chair. It was mentioned that it's not wiretap. However, the first line of the bill states in the synopsis that it's intercepting a wire.
Yeah, this goes to the amendments. Yeah, here's the amendment. So exactly, this is back to the exact same question. So I think the wires got crossed between the sponsors and the drafting office. And I kind of see where the ambiguity or honestly the confusion would lie about intercepting a wire communication and how that could maybe trigger memories of the wire. Other than to make clear, the amendment is trying to clarify that all we're talking about is that when I have a conversation with a housing provider, if I'm the tester, I can record it like with an iPhone. I'm not intercepting any devices. We're not talking about testers tapping someone's phone. That's not what the bill is talking about. I think probably the language would have sufficed, but I think it's confusing enough that the amendment is necessary.
And just to clear, thank you, that there is testing going on in Maryland today.
Yeah. Oh yeah.
Yes.
Yeah. There's always going to be testing. There's testing happening in all 50 states. The question is, are we going to have the best available evidence to test? And are we going to be able to have testing that protects the actual recording of what actually transpired? Or are we going to be basing testimony on the faulty human mind?
I gotcha. It seems to me like any phone call that's made nowadays, it's like this call is being recorded for testing or purposes, training purposes, quality assurance.
Well, I think correct me if I'm wrong, Delegate Schmidt, I think you're sort of in this industry, right? And I think realtors in particular, and to your point, he used the term pedestrian to describe this. This is not a radical concept. In fact, if you talk to people in 39 other states and told them that we couldn't record for housing testing, they'd look at you like we were crazy. This is not some utopian or radical proposal. And I think to that point, the realtors have submitted favorable testimony. These are the folks that would be most on the hook probably of getting dragged into court for this, and they're in favor of the bill. And I think to your point, every realtor, every good realtor or landlord should know that when they're having a conversation with a prospective renter or homeowner, that is not a private conversation.
Right.
That's commercial speech. Everyone knows it in the industry. And I think it's sad for good realtors. 99% of folks in this industry, from realtors to mortgage servicers to landlords, are good people abiding by the law. And I think it's messed up that the entire industry is essentially painted over and with the terrible actions of just a small minority.
Yeah, thank you.
Thanks.
Thank you.
Seeing no further questions, thank you very much.
Thank you, Mr. Chair.
Now we're going to the second panel. David Skinner, Lisa Sorrow, Albert Turner, Lisa Kelly. Words me and two seem to ring in my ears a little bit, but you know, a guy can dream. Whoever'd like to begin.
Good evening now, Mr. Chairman and Vice Chair. Members of the House Judiciary Committee, my name is David Skinner, and I'm the Fair Housing Compliance Manager at Baltimore County Department of Housing and Community Development. I'm testifying in support of House Bill 392, which aims to enhance the state's fair housing enforcement. This legislation proposes a vital adjustment to Maryland law, allowing fair housing enforcement groups and government agencies to conduct audio and visual recordings for fair housing testing, or as known all over any industry, mystery shopping. This exemption would apply solely to discrimination testing activities of housing professionals in rental housing, home sales, and home mortgage lending. As a recipient of federal funds and as required by the Baltimore County's 2016 Voluntary Compliance Agreement, known as the VCA, the county has a legal obligation to affirmatively further the goals of the Fair Housing Act by annually funding fair housing activities, which include education, outreach, complaints and referrals, tenant advocacy, and the fair housing testing. The county currently allocates about $260,000, not about precisely $260,000 a year for such activities, of which $50,000 is obligated to fair housing discrimination testing, this mystery shopping that we're doing. And to Delegate Arkin's point, fair housing testers, they're just regular people. They're trained, ordinary constituents throughout the county, people such as postgraduates, retirees, stay-at-home parents. During the latter half of fiscal year 2022, 70% of the mystery assignments in Baltimore County indicated potentially discriminatory policies or practices. Currently, Maryland law unintentionally diminishes fair housing enforcement, potentially offering protections to violators instead of protecting its residents seeking housing opportunities. Discrimination, whether overt or covert, isn't always obvious to residents, especially while sharing sensitive information to access housing. And passing House Bill 392 will significantly enhance efforts to deter illegal housing discrimination, and Baltimore County urges a favorable report.
Please, next.
Good afternoon, Chair, Vice Chair, and members of the Judiciary Committee. Please be advised that the Baltimore City Administration supports House Bill 392. My name is Lisa Kelly. I am the Chief of Investigations and the Acting Deputy Director in the Baltimore City Office of Equity and Civil Rights. Baltimore City is often referred to as the home of redlining because one of the nation's first discriminatory housing policies was passed by city government in December 1910. Baltimore's redlining model was implemented nationally and led to years of discriminatory practices. Baltimore, and by extent, Maryland, led the nation in one of its most shameful chapters of history. This led to concentrated poverty, poor education outcomes, and high crime rates. However, Baltimore is also home to one of the oldest civil rights enforcement agencies in the country, the Community Relations Commission. The Community Relations Commission is one of 6 boards and commissions housed under the Baltimore City Office of Equity and Civil Rights. CRC staff investigates individual discrimination complaints in the 5 areas of Baltimore city life, one of those being housing. The purpose of fair housing laws is to guarantee people a choice in where they live. One of the best tools in stopping housing discrimination is conducting fair housing testing. Furthermore, best practices dictate that testers record their interaction through the use of concealed recorders. Audio recordings accurately capture entire interactions, ensuring full transparency and accountability. In 39 states across the United States, these trained testers can record their conversations with property owners and managers, and those recordings can be used to help enforce fair housing laws in court. Testers diligently endeavor to take accurate notes during a housing interaction. However, written records can be challenged and denied by bad actors. Audio recordings provide direct evidence of violation. Such evidence can even prevent further enforcement action by compelling bad actors to correct their behaviors before further action is needed. For these reasons, the Baltimore City Administration respectfully requests a favorable report on HB 392. Thank you.
Good evening, Chair and members of the committee. My name is Lisa Sorrow. I am General Counsel at Arundel Community Development Services. ACDS is Anne Arundel County's nonprofit housing and community development agency. Before I came to ACDS, I was an attorney in Maryland practicing with the state's most vulnerable residents, low-income Marylanders, helping them to get and maintain housing. I submitted ridiculously long testimony, written testimony that addresses many of the issues that you all were discussing before. But what I really want to talk about in my little bit of time is the testing program that we are currently operating in Anne Arundel County. We contracted with the Equal Rights Center less than a year ago. Since that time, the ERC has conducted about 50 tests. We focused on disability discrimination, source of income discrimination, race and ethnicity. What we get in response to the tests that have taken place is a summary of what occurred. Some of them have been in person, some by phone. So we get a summary. Why did we want to do this? We did audit testing to start with because there hadn't been a testing program before. So we sent out testers all over the county to get a feel for whether there's a problem. We don't want to use taxpayer money to solve a problem that doesn't exist. Well, not surprisingly, there's a problem. We don't anticipate at any point that we would jump from a recording that discovers discrimination straight into court. Those recordings are going to be used as a teaching moment to start with. They're going to tell us what we need to do outreach in to make sure that residents of our county know what their rights are, and also to educate landlords, realtors, and others. So we use that testimony, which would be best in a recording form, to work with the purported wrongdoers to make sure they get it right the next time. It's not a gotcha thing. It's how do we make it better for everyone thing.
Thank you.
Thank you.
Mr. Chairman, Vicewoman, Chair, my name is Albert Turner. I'm a staff attorney in the Human Right to Housing Project at the Public Justice Center. We provide representation for tenants in Baltimore City, and we also do some impact litigation as well in the state of Maryland. I won't belabor the point. Something that we get pretty often from tenants is calls stating that they were denied because of their voucher. I called a landlord, I called a housing complex, and I asked them, did they take vouchers? And someone on the other line told me no. That is obviously not something that is that's illegal under the Home Act that was passed in 2020. We get these calls, and oftentimes when we try to do follow-ups with them, because there is no best evidence, there is no recordings, it's very hard to come back to the landlord to try to negotiate whether or not they can get back to the unit, whether or not the person that told them that they were not taking vouchers was actually someone in charge, or whether there's a miscommunication or along the lines of that. And so for those reasons, we like to have these type of best evidence for the purposes of what my colleagues have said, is that we want to be able to come back to the landlords and say, this is something that you cannot do. There's a voucher denial, which is in violation of the bill that was passed by this General Assembly. And for those reasons, we would come out in favor of this bill.
Thank you, Mr. Chair. I just have a quick question. I'm going to direct it to ACDS because that's my county and I know you all. Why not just go out in twos or threes?
Well, for a couple of reasons. One, cost, right? We're using government funds to support this testing program. It's much more efficient and more cost effective if we can send out one person with I'm sure it would actually be an iPhone pressing play to record conversations. As it is now, we have to have, if it's an in-person encounter, the one person going in, say with a disability, has to have that communication, that interaction, and then come out and try and write it all down as quickly as they possibly can and get it right and include intonations and stalling for answers and tone. And that's all going to be subjective.
Okay, I got it. Thank you.
You're welcome.
Thank you, panel. Today, the governor spoke about Maryland being the best place for all. And I think when we look at housing, that becomes the big question, is it the best place for all? My question to you all and each of y'all, when we talk about the investigative authority of each of your agencies, what is your qualifying, how do you qualify as an investigator or someone that looks into these type of cases?
So speaking from Baltimore County DHCD, we don't have investigative authority. Our 2016 HUD voluntary conciliation agreement precludes us from doing testing ourselves. So we have to contract services with someone like who you heard earlier, Marceline White from Economic Action Maryland, or another agency like Equal Rights Center.
And similarly, OECR has explored in the past working with Economic Action Maryland and has worked with the Equal Rights Center in the past. However, our city Department of Housing and Community Development is the actual department that conducts the testing.
Yeah, in Anne Arundel County, similarly, retains trained experts to do the testing. Although our Office of Equity and Human Rights ultimately will probably have authority to do tests themselves. But right now we rely on the experts because we want to be sure we are getting the best evidence and the best testing. And it requires training. It requires experts doing this. And that's not something we have in-house.
Public Justice Center, we don't have the investigative aspect of this bill. We are the representatives for the tenants who are denied based on these type of housings.
So the prospective agencies, all of y'all deal with agencies outside of your own for the purpose of investigation. Thank you.
Seeing no further questions, thank you all very much. That concludes the panels of those people in favor of the legislation. We're now going to the panels opposed. Aaron Greenfield and James Johnson.
Good evening, Mr. Chairman, Madam Vice Chair, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association, and we are in opposition to House Bill 392. You have our written testimony. I'm joined today by Jim Johnson, the former Baltimore County Police Chief, who's here at my request. I haven't seen the amendment, but very curious to see how they change the term wiretap, which is very evident in the bill that that's what this does. It is a form of wiretapping. But in an unprecedented manner, this bill expands the wiretap statute to a non-criminal context. If the proponents want to eliminate the two-party consent to reach this aim, then that's what we should be discussing, not creating exceptions where there is a reasonable expectation of privacy. And under the Bedoy versus North Anne Arundel hospital case, the wiretap statute is very explicitly intended to prevent in non-criminal situations the unauthorized interception of conversations where one of the parties has a reasonable expectation of privacy. Housing providers have a reasonable expectation of privacy. Allowing wiretapping by a nonprofit for fair housing claims may in fact set a precedent for expanding such surveillance powers to other contexts, potentially leading to abuse of those measures. Who is next? Bankers, journalists, tax professionals, elected officials? Let's continue to promote education and awareness programs for both housing providers and residents, to foster a better understanding of fair housing laws and practices. And for those reasons, we respectfully request an unfavorable report on House Bill 392.
Good evening, Chair, members of the committee. As a 45-year law enforcement professional, former chief of police for a very large Maryland department, and a multi-housing professional, I urge you to give HB 392 an unfavorable report. Maryland law enforcement seldom conducts wire intercepts or wiretaps. They're seldom conducted across the nation, by the way. It might come as a surprise. Of another individual without their knowledge, and only if they receive the equivalent of a search warrant based upon probable cause from a circuit court judge. Wire intercepts are only used for our state's most serious violent crimes, including kidnapping, sexual assault crimes, and drug trafficking violations and homicides. Filed affidavits requesting intercepts contain detailed information, including, among many other factors, sworn statements that detail why you believe a crime was committed or being committed, who's committing it, the length of time that you want to conduct that intercept. In addition, details of the investigation, all the efforts you've made in the past and why they failed to get the information that you want or need. Judges must find probable cause, not a speculative possibility that a target could possibly give you information that you need to investigate in the police case a serious crime. Police agencies have strict regulations and procedures. This is really important. Police officers are held liable for disclosing intercepted information unlawfully. These intercepts are conducted in very secure facilities with well-trained individuals with extensive backgrounds. I can't overstate this, the cost of human resources and dollars to secure this evidence and chain of custody that in this particular bill will be used in civil litigation, costing Marylanders and others tens of thousands of dollars if they're brought before the court.
Delegate Embry.
So much for being here. So I view this as more similar to the law enforcement exception for a controlled call, because that's what this is. It's allowing a phone call where there's one party who has knowledge that it's being recorded and one party agrees to participate. And that, isn't it true, requires no warrant. None of the things you described, which are required, of course, when you're asking a phone company to put a what is conventionally called a tap on a phone. Am I wrong in that analysis?
Well, I think that what's missing in that discussion is there's some probable cause to conduct that controlled call. You base it upon the investigation you've already conducted and a reasonable belief that a crime has been committed in the case of a controlled call or is being committed.
Thank you.
Thank you, Mr. Chair. So I'm just wondering out loud, and maybe you guys can answer this, maybe the officer can. He's a retired officer. Let's say something was recorded that has nothing to do with housing. Once we have the recording, it was lawfully recorded. Can it potentially be used in other cases? Like once it's introduced as evidence in court on one civil issue, can it be used in a slew of things?
I'm not a prosecutor, not an attorney, but I would strongly believe that what I disclose in this scenario to a tester, the entire delivery, the message could be used by a prosecutor for any sort of crime.
Or maybe even another civil case or something like that. Potentially, I don't know, but we'll have to see. We'll have to ask some prosecutors and find out. I'll have to ask my chair.
I would add too, the personal exchange.
Shaking his head.
The personal exchange that takes place between a prospective tenant and a leasing agent. These are personal discussions held in private offices in many cases.
Right.
And out of earshot of other tenants who you don't want them to hear about your financial situation. So these are private conversations is my point.
Okay, yeah, thank you, guys.
Thank you, Chief, for being here. And I just want to ask you, you spoke about your years of service and working in community, working in housing and things of that nature. Would you find today, as the governor once again spoke about Maryland being the best place for all, do you find that there is discrimination in housing?
I can tell you amongst the professional multi-housing providers that we represent and deal with daily, the answer is no. Maryland recently passed source of income regulations that no longer will disallow one with a housing choice voucher, for example.
You don't believe there's no discrimination in housing at all, or just?
Oh, no,
in
sir.
your specific
I am
case?
sure that the individuals that were on the panels before have identified land property owners, leasing agents who made statements that were incorrect, inaccurate, and even unlawful. So I'm sure you couldn't find individuals. But again, it's a speculative possibility. You're calling someone, you're approaching someone cold. Oftentimes, by the way, a 18 or 20-year-old who just last week finished fair housing education school, they may have just misstated a company policy or procedure. Just keep that in mind too, that many of these leasing agents, haven't been on the job for 25 or 30 years.
Thank you, Mr. Chair. I think you just answered my question, but so training, you mentioned training and the amount of work you do to make sure that when you do seek to record a conversation, that the person is trained to make sure they know how to do it. The previous folks testifying indicated that there's some, I think that there's some shadowing, there's a little bit of training, but can you describe what an officer goes through before they do wiretap?
What I heard from the previous panel and the testimony across the street, it seemed to be dependent upon the agency. There's different training. It's what wasn't uniform. For police officers, to be extensive training in operating machinery, logging, keeping information, controlling that data, maintaining the chain of custody. Don't lose sight of this issue of chain of custody. It is critical in bringing a case forward. And again, the safekeeping of that evidence and secure facilities that are extremely costly, using equipment again that's specifically for wiretap operations. So again, I think the training for this probably would be around 40 to 60 hours worth of training for a police officer.
Thank you.
Good evening, gentlemen, and Chiefs, good to see you.
Good to see you again.
All right. You may have kind of helped me think through a way that this could work. I'm a big fan of kind of this dual consent. And so the idea that we would begin to chink away at that with an exception concerns me a little. But you mentioned probable cause. So I want to run a scenario. What if you had a tester that went out and the tester asked the question about vouchers, and they were told that they did not, this particular rental agency did not accept vouchers. And they wrote that down and they've gone back and they say they want to be able to confirm it. Now I do have, in some respects, probable cause. Now, can I go back and have that conversation and record it? Would that be sufficient probable cause? Once again, this is not a criminal matter, but to try to figure out a way to confirm for those testers. How would the industry feel about something like that?
Well, I think, the proponents were very clear that this is intended to be civil.
Civil matter.
There's still some confusion, but the OAG, I think, cleared it up this evening. I think based upon that seems like a somewhat reasonable approach. If there's some training that has failed and the tester recognizes that the housing provider is doing something illegal, then maybe you do come back and test that again with that information. Again, it's not probable cause because this is a civil matter.
Correct.
But I think that's something that's a reasonable next step. But to your first point, opening this up, this two-party consent with these exceptions is really not the way to do it in our estimation.
Thank you.
Thank you. I'm sorry. I just want to, I don't know if you've had a chance to see the amendment, but it does make it clear that there's no implication for criminal exposure. Does that alter your, because I know that's a concern that there, without any probable cause, you wouldn't want someone exposed to criminal prosecution. But this would, I think, as I read it, make that impossible and provide that protection to the people who are being recorded. Does that alter your analysis in any way?
Not really. I think it's a help. But as Chief Johnson mentioned, you know, there's lots of training, there's chain of custody issues that are unaddressed. How do fair housing testers go about those responsibilities? So I think it's much more involved than simply that amendment. Although again, I look forward to the amendment and always have a great relationship and hold the sponsor in the utmost respect. So we'd be happy to entertain it.
Seeing no further questions, we thank you very much. I'm sorry, Delegate Grammer.
Thank you. Hypothetical situation, if you have a tester, could the tester not just say, I'd like to record this conversation, is that okay? Would that not, in the situation where they're coming out, they want to verify compliance, we could get away with the whole issue of having to record, have the two-party consent if they just actually got two-party consent and they said, we'd like to record this conversation.
Yes. I mean, yes, that would be the two-party consent and that would be fine.
You're here for MMHA. This also applies to like Uncle Bob who owns one rental property and he's going to have to be faced with these kind of scenarios. This is not just big apartment complexes, big housing complexes. This is also individual property investors. Is that correct?
That is correct.
Thank you.
Thank you, Mr. Chair. I guess I want to follow up with that. So if I know that I'm being recorded, is it a good chance that I may or may not answer in the way that I would if I knew I was not being recorded?
If you're operating a professional multi-housing property or singular unit, you want your unit filled. You want to do it lawfully. Vacant units cost the industry money. So again, I think a professional operator would know the law and comply with it.
Okay, thank you.
Seeing no further questions, thank you very much. That concludes the testimony on House Bill 392. House Bill 330 is next. Delegate Rosenberg with the bill we have heard several times in the past. Delegate Rosenberg, if you'd like to bring your panel up, that would be fine.
If
you're signed up.
Yes.
Ron Jerichow, Tom Cole, Maxwell Mishkin, Catherine O'Malley, and Rebecca Snyder. If you just want to add a chair, we'll just add a chair. There's only one person in opposition, not saying anything about just only, but still one person in opposition. Go ahead.
Mr. Chairman, in light of the fact that this bill has been sent to the floor and to the Senate by this committee, and that this committee is well aware of the need to protect individuals, neighborhood groups that we all represent from the indignity of a slap suit, I will simply say, me too. And defer to my other witnesses.
Would you like to get it? You can. Okay.
Good afternoon or good evening, everyone. I'm Rebecca Snyder, Executive Director of the Maryland, Delaware, DC Press Association. And yes, as Delegate Rosenberg has said, you have passed this out of committee 3 years running. And so we are hopeful, and I urge a favorable report this year as well. The Press Association represents news media. However, this is not simply a news media issue. It affects individuals, it affects community associations, all sorts of people. And I would direct your attention, when you have the time, to listen to our podcast that just dropped today about SLAP and going through some of the fine tuning aspects of it. It is time to shore up Maryland's commitment to public discourse. There are no protections at the federal level. There is no anti-SLAP statute waiting in the wings to protect us. Maryland has a D rating for its current anti-SLAP statute, and the Supreme Court is mulling. The outlook there is a little uncertain for some of the bedrock rulings in Sullivan. So this is a necessary time. I urge this committee to pass it forward, and look forward to comments from the rest of the panel. Thank you.
Thank you. Good evening. I'm Katie Kern O'Malley, and I'm currently the Executive Director of the Women's Law Center of Maryland, and we are urging a favorable report on this bill. From the perspective of the clients that we represent at the Women's Law Center, they are victims of intimate partner violence and/or sexual assault, and we also have a good deal of Title IX investigations going on with victims of sexual assaults. And I can tell you from talking with the attorneys at the Women's Law Center that they have had to represent these victims, survivors of sexual assault and survivors of intimate partner violence, on defamation claims way too many times as a result of sort of retaliatory actions against the clients. So I urge a favorable report on this. I want to commend all of you for your long hours of listening to testimony. I had no idea how long these hearings can go, but I want to just say that I was very impressed with all of your questions that you asked on the variety of different issues. So thank you for working so hard on behalf of Marylanders and listening to us so late into the evening.
Good evening, and thank you, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Max Mishkin. I'm an attorney in the Media and Entertainment Law Group at Ballard Spahr, and I appreciate the opportunity to speak tonight in support of House Bill 330. I'd like to touch on just a few points from my written testimony about how this bill would improve the Maryland anti-SLAPP law and why that's such an important step forward for our state. First, the changes that House Bill 330 would provide have a proven track record. You can look at anti-SLAPP laws across the country, and you'll see that state after state agrees that when someone sues over speech on a matter of public concern, the person suing should have to show early on that that case has merit. Likewise, you'll see a consensus that when a plaintiff brings a meritless SLAPP lawsuit and loses, the plaintiff should have to pay the defendant's attorney's fees for the trouble. These are the kinds of provisions that make an anti-SLAPP law effective, fair, and reliable. Second, a stronger anti-SLAPP law helps organizations of all kinds and people of every political leaning. I've seen that firsthand as my colleagues at Ballard Spahr have filed anti-SLAPP motions for conservative anti-abortion filmmakers being sued by a Democratic state court judge, and for a national Democratic advocacy group in a lawsuit brought by a GOP mega donor. In just the past few years, we've asserted anti-SLAPP provisions against an iconic Republican sheriff and against a rising star Democratic lieutenant governor. Anti-SLAPP laws are not a partisan issue. Third, now is the time to put these protections in place. Libel bullies bring meritless lawsuits every day because they feel confident that even if they lose the case, they can still win the fight. They can make defendants spend time and money and think twice before expressing themselves again. House Bill 330 is the right bill to take on this growing threat to free speech. I encourage you to report it favorably. Thank you again for the opportunity to testify this evening, and I'd be happy to answer any questions.
Good evening, members of the committee. My name's Tom Cole. While normally I would be representing clients, I'm here on my own personal behalf. I'm one of the few defendants that succeeded in a SLAPP motion last year. In February of 2021, I took a case on behalf of my client on a deferred fee basis. She was sued for defamation because of a blog post. 2 days after I took that representation, I was sued by that same plaintiff. Later in that case, we had a defense witness who was deposed. A week after she was deposed, she was sued by that same plaintiff. The plaintiff's husband was an attorney. All of those cases had SLAPP motions filed. Mine was the only one that was granted because it was obvious that I had been sued because I entered my appearance as an attorney. The other two cases went to trial. The defendants succeeded at trial, and they're now pending down the street at the Court of Intermediate Appeals. This is wrong. Maryland should be protecting free speech. This committee knows it. It's referred this out before. But a lawsuit is an injury in itself. If I had not accepted that case on behalf of my client on a deferred fee, that would have been hundreds of thousands of dollars to take that case to trial. And we did take it to trial. This is not a free state. If anyone can have their husband file suit against anyone who they perceive as wronging them and know that that lawsuit in and of itself is an injury to them, this is creating nightmares. Even as experienced as I am as a litigator and doing this kind of work, I had to explain to my wife and my kids about what a lawsuit is and what would happen if we lost. It's not right. So I ask for a favorable ruling. Thank you.
There we go. Thank you, members of the committee. My name is Ronald Jericho. I'm testifying on behalf of the Maryland Association for Justice in support of this bill. I'm a former judge on the Circuit Court for Anne Arundel County. I went back into practice in 2011. We submitted a position paper in which I cite an organization that did a study of the 34 states. Maryland ranked 0 of the 34 states with Maryland SLAPP statutes. This bill modernizes the Maryland SLAPP statute and brings it into consistency with the rest of the laws across the state. In terms of personal experience, I worked in 2020 and 2021 with Delegate Rosenberg to improve this bill so that it's the current state. And so we are in support of it. It's overdue. It's been pending a long time. I was a defendant in a SLAPP suit about 4 years ago when I criticized a judicial authority in the District of Columbia who sued me in the District of Columbia over that because of the ethics violation she had committed. And that is a story about how these cases come about, the claims of defamation, interference, etc. Fortunately, I had an insurance company that would defend, others don't. These cases, these anti-SLAPP statutes protect against, and the attorney's fees you heard mentioned only is one side. It's a balanced attorney's fee provision. That is that if somebody brings a frivolous lawsuit, they will pay the attorney's fees to the defendant. But if the defendant brings a frivolous motion to dismiss, the defendant pays the plaintiff attorney's fees if in fact the case is meritorious. So bear that in mind. We support this bill and ask for a favorable report.
Chair, we've seen this bill a couple times. What's happening in the Senate?
Well, I would suggest that
It's a really good question, evidently.
I don't think it's ever come to a vote, they just have, this committee knows better than I do.
It happens all too frequently over there. Is there any discussion?
We are working with I'm reaching out to Senate leadership and seeing what we can do in the committee.
Okay.
And we
Thanks.
have a very strong sponsor who is very committed to the bill.
Keep us in the loop.
Will do.
Much. That
Thank you.
concludes the
Thank you.
testimony, except for one person in opposition. So we're going to hear right now from the person in opposition, who I almost forgot, which I apologize for. That's Laura Bogley, please.
Thank you so much, Chairman Clippinger, members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life. Thank you so much for your time today. I know it's been a grueling day for you, but I want to make this really easy. You've heard this 3 other times, right? And the Maryland General Assembly has chosen wisely to reject this 3 other times. And there's good reason for that in the law. But I want to thank the bill proponents for making my case for me. But I have to ask whether any of them actually read the law or the bill that you're voting on or that you're hearing today, because the bill that they are supporting is not an anti-SLAPP law. It's a pro-SLAPP law. We have a very good, effective anti-SLAPP law that this assembly enacted that is on the books. This bill before you is to create a giant loophole in that SLAPP law. This is encouraging or allowing more SLAPP lawsuits. This is suppressing speech. Okay, so why is that? You have to look at the operative sections of the bill. it creates a huge loophole where it redefines what is a slap suit. And it says there's a huge category of things that are no longer going to qualify as slap suits. What does that mean? That means the little guy who I'm here to represent today, who I'm always representing, is going to be denied an affirmative defense under the law to create the balance that the proponents were asking for, right? We want to encourage public participation. We want to encourage free speech, regardless of who the speaker is or the content of the speech. This bill will suppress speech. I call it the bully loophole, and that's what it is. It allows wealthy, well-connected people and groups like the Washington Post to continue to defame and malign people and not grant them an affirmative defense to say this is a slap suit so they don't get into those costly expenses. And please see my written testimony that talks about Nicholas Sandman, who was successful in his lawsuit against the Washington Post for defamation. I urge you to vote no. Thank you.
Questions?
Please.
Delegate Grammer?
Mr. Chair, thanks for being here, Ms. Bogley. How would you fix it if you had to do so?
Thank you for the question. If it ain't broke, don't fix it. Your current SLAPP law is strong. It's working well. This creates a loophole so that people will be immune to the anti-SLAPP law. So your original intent was to prevent frivolous lawsuits. This does the opposite of the Assembly's original intent.
By looking at the definition, which is what you brought into question, it looks like it broadens the definition, and we could debate that, but is that your concern?
Right. If you delegate, if you look at my written testimony, it breaks out the specific section, which I think is paragraph C, and it says this is not a slap suit. This does not qualify as a slap suit. So it creates a huge exception for different behavior, different suits, frivolous lawsuits that now are no longer accountable under this law. So it's saying, okay, we don't like slap suits. We want to encourage public participation, but we're going to allow these frivolous lawsuits. We're going to just not look at these. We're going to say these aren't defined as slap suits anymore. And it's something very broad, like saying a lawsuit brought in the general public interest or to enforce an important public right is no longer considered a slap suit, right? But really, it should be the court that decides that. This exception, this loophole, takes away the certainty for the courts, which they have now under the current statute.
Okay, thank you so much.
Seeing none, thank you very much. Now we conclude the testimony on House Bill 330. Go to House Bill 359. Delegate Long, who is here before us for the first time and should be tortured accordingly. All right. Delegate Long, please, for 3 minutes.
Already. Thank you so much, Mr. Chair, Chair Clippinger, Vice Chair Bartlett, and colleagues of the Judiciary Committee. You already have my written testimonies. What I won't do is reiterate that. I'll just give you something different. HB 359 is aimed at protecting vulnerable Marylanders diagnosed with disabilities that impair their ability to make reasoned decisions regarding their person and property. This bill, as proposed, would require an automatic stay of specified civil actions and proceedings when a petition for guardianship of the property of an alleged disabled person is filed. The stay would remain in effect until a guardian is appointed or the petition is denied. I'm sure you all are already familiar with how the adult guardianship process commences and ends, but I'll just briefly touch that. 1, the petition is filed by the petitioner, example, local Department of Social Services. Secondly, the court appoints an attorney from an approved list to represent the alleged disabled in the adult guardianship proceedings. Please note that the court-appointed attorney is only legally contracted with the state to represent the alleged disabled in an adult guardianship and not other legal matters. Number 3, the petitioner serves the show cause order and pleadings according to Maryland rules. For example, a hearing in Prince George's County is typically set for 4 to 5 months after the petition is filed. Number 4, a hearing is set to appoint a guardian. Number 5, the court appoints a guardian of the property from a court-approved list of attorneys who have completed the necessary training to manage the property finances of an individual adjudicated disabled. Like the automatic stay in bankruptcy proceedings, when a debtor files for bankruptcy, an automatic stay halts creditors' abilities to collect until a trustee is appointed to reorganize the debts. This process does not aggrieve creditors. Debtors obtain necessary relief to reorganize debts and payments to creditors. This proposed bill, the temporary stay, would not aggrieve landlords because it permits the disabled tenant to have a court-appointed guardian manage their finances to become current and pay any back rent. The legislation permits the temporary stay to be in place until a temporary and permanent guardian of the property is appointed, which typically will take at most 5 months, but can range from jurisdiction to jurisdiction. Legislation protects vulnerable Marylanders who have been diagnosed with a disability that prevents them from making reasonable decisions concerning their person and property. Disability can include the following: dementia, mental health diagnoses that affect cognitive thinking, and a physical disability that puts an individual in a vegetative state. Briefly and lastly, I want to give you 2 real life examples that have taken place that have happened rather in Prince George's County. Individual A was diagnosed with dementia, spouse is deceased and no other relatives to offer support. Individual A owns the home, but due to the dementia diagnosis has not paid the taxes. As a result, there is a sheriff's sale and the home is sold while the adult guardianship process was pending. After the sheriff's sale, a guardian of the property was appointed. The guardian of the property identified that individual A had enough equity and or money to bring taxes current and save the home. But in Maryland, there is no right of redemption or recourse to reverse the sale of individual A's home. And had a proposed temporary statement in place, the sheriff's sale would not have happened. There are several stories I can share. I ask for this committee's favorable report and consideration of HB 359. Thank you so much.
Good evening. My name is Jim Silver. I'm the supervising attorney for the adult guardianship program at Maryland Legal Aid. I did submit written testimony, so I don't want to belabor the point and repeat all that. I do want to just emphasize that current Maryland law does not provide any protection of this type for people facing guardianship. Our guardianship clients usually come to us after a lengthy hospitalization or stay in a nursing home, sometimes experiencing significant medical problems. They might have a temporary difficulty understanding the petition for guardianship due to accident or medical condition. They have the right to object to the appointment of a guardian and resist the matter in court. This bill would allow our clients to focus their attention on a proceeding that could permanently affect their right to make decisions for themselves and would also protect against the potential default and loss of property. So Maryland Legal Aid urges a favorable report on HB 359. I'm happy to take any questions.
Yes, welcome, Delegate Long.
Thank you.
I just have 2 questions, if I may, Mr. Chair, and that is, my first question is the judiciary is opposed to your bill. Okay. Which is pretty frequent. Take it as a badge of honor. But anyway, the point is that my point is they say they lack the capacity to do this. And so I just wanted to know if you had a response to the judiciary's opposition. And then my second question is, did you get positions on your bill from organizations such as Disability Rights Maryland, the Maryland Developmental Disabilities Council, AARP of Maryland, or the national, some of the association area agencies on aging that provide services to people, older adults in Maryland?
Thank you, Delegate, for the question. Number one, I do want to lift up the fact that I did have a pretty productive conversation with Judiciary on Monday, and they offered some amendments. So at the bottom of their opposition, you'll see that they feel it could be accomplished if we give them flexibility to stay any actions upon filing of a petition to stay. And so I'm amenable to that. And I believe that they're also in conversation with counsel. Secondly, to answer your second question, we did reach out to some particular groups such as AARP and others. We also work with Office of Aging as well, but they have not decided to take a position, but wanted to just see how the hearing went. But again, we did reach out to some. And DHS, you may see, did submit a letter of support.
Okay, well, thank you. And if any of those groups that are on the sidelines right now make a decision regarding their position, please let the committee know. Thanks.
Will do.
Any other questions? Seeing none. Thank you very much for surviving your first bill panel in judiciary.
Thank you.
Now, and now for Mr. Bob Benton now, favorable with amendments.
Thank you, Mr. Chairman, members of the committee, Robert Enton, testifying on behalf of the Maryland Bankers Association. What caught my attention with this bill was that it would include a stay of a foreclosure proceeding. And I think you have, I think in your written testimony, a memo from the Maryland Judicial Conference talking about the problems, which this, I think, more procedural in nature. But I agree. I think that the biggest problem I have with this bill is that it creates an automatic quote unquote stay. And that stay is in effect until such time as these cases are filed in circuit court, until that case is adjudicated one way or the other. Well, I don't know how long that's going to take. Is it going to take a year? Is it going to take 6 months? Is it going to take 3 years? I think what you have to be careful about is that if you can, if I'm the defendant in the case, whether it's a landlord-tenant case or a foreclosure case, whatever it is, and I got a lawyer that's tracked this bill the way it's introduced, I can file a petition for guardianship for my client, and it can just sit there for who knows how long. So what the courts are suggesting is that, as they do in bankruptcy cases, is that the bill be amended to give the courts the flexibility to stay actions. And I'm fine with that. I'm fine with that. Because then at least you're going to have a chance to go into court, into the circuit court, and make, an argument that this is frivolous, that this is the 5th time that they've filed a petition for guardianship, gotten a stay, dismissed it, filed another one, gotten a stay. So I think that's workable, Mr. Chairman. I guess the other thing I would suggest is that we make it clear in this bill that the effective date, that it's only effective to legal proceedings instituted on or after the effective date of the bill. I don't want to have a trial or a foreclosure case that I've been working for 2 years and it's about to go to jail and be ratified. And then all of a sudden now, because this has been filed, it affects pending cases. As long as we know this is prospective, I think we're fine with it. I think with those couple changes, I'm happy to work with the sponsor and the committee and with the court judiciary to come up with a reasonable set of requirements for the bill. And with those, we'd be fine. Thank you.
Any questions?
None?
None. Thank you very much. That concludes the testimony for House Bill 359. You don't applaud Bob Enton. No. Don't applaud. Well, no, that's true, but I'm just saying he's been here before. Delegate Long hasn't been. All right. Both testifying. We have now House Bill 329. And I have Delegate Grammer, Sarah Mastronardi, Richard Norman, Mark Pennack, who's here, come on up. And then virtually John Jocelyn and Galen Muhammad. Are they there? Okay, we'll take him.
I really want to touch this button.
Please don't. Please don't. We need to make sure that the microphone is on. Thank you.
Thank you, Mr. Chair. Madam Vice Chair, members of the committee, for the record, Delegate Robin Grammer here to present House Bill 329. House Bill 329 extends the duration of carry permits for retired law enforcement officers. Very simply, this bill recognizes law enforcement officers who have likely carried a firearm every day for the duration of their career. It offers a renewal period of 5 years for officers who have retired in good standing, with a renewal period of 5 years. I'd be happy to take questions and ask for a favorable for House Bill 329.
Thank you, Mr. Chair, Madam Vice Chair, Delegate Gary Simmons. For the record, I stand in favor of this amendment to the 5 years dealing with handgun permit requirements for Maryland law enforcement agencies. As stated previously, law enforcement officers go through a year's time of nomenclature and weapon retention. which makes them eligible for this law to be enacted on their behalf to ensure that they can work in good standards in a 5-year period rotation time for renewal of their license. So I ask for a favorable in reference to this legislation.
Yes, sir. Good evening, Mr. Chairman, Madam Vice Chair, and members of the committee. My name is Rick Norman. I'm a retired captain with Maryland State Police, serving citizens of the state of Maryland for over 28 years. I'm currently the executive director of the Maryland Trooper Association, which represents 2,600 members, active and retired, about 1,500 retired members of the Maryland State Police. We are here to support House Bill 329 to extend handgun permits to a 5-year renewal period for retired law enforcement. Retired law enforcement have to retire in good standing to get their initial permit. That means there's no internal investigation. There's no pending background instances with the officer. In addition to retiring with good standards or in good standing, we get our badge, we get our ID card, which is, we cherish that for basically being a law enforcement officer in Maryland. And we just don't stop there. The Maryland State Police has to do a license check, an annual background check on everyone that has a permit. So it's not like you just give a law enforcement officer a handgun permit and then 2 or 3 years later you renew it. Every year they go through a background check. There's a wrap back program that if anything happens with the law enforcement, they get charged with any crime. Licensing division immediately is notified of it and they can withdraw the handgun permit at a minute's notice. The renewal cycle coincides with other states, I understand, which is about 5 years, and it certainly would help burden or ease the burden in the Maryland State Police, who has over 150,000 handgun permits out there, and they have to go through the renewal process, and it would save them money. As a delegate pointed out, we spend our life as law enforcement, and when we retire, we still do the same thing. A friend of mine who I graduated with came upon a burning car 2 years ago, had to break a window to take 2 people out of it and save their lives. You know, a year ago, Sergeant Phillips on the Eastern Shore was shot 3 times by 2 suspects who ran into a construction area and was apprehended by a retired law enforcement officer that had a handgun permit. We recognize them as they were law enforcement officers. We would like to recognize them as retired, and we ask for a favorable report on House Bill 329.
Thank you. Honorable delegates of the House Judiciary Committee, representatives, guests. I'm retired First Sergeant Sarah Mastronardi. I have over 30 years of experience with the Maryland State Police. I'm currently president of the Maryland State Police Alumni Association. We represent about 1,500 retirees and their spouses. I'm honored to speak to you today regarding this handgun permit extension. Upon my retirement, I was afforded opportunity to get my handgun permit as soon as I retired. Of course, you've already heard about the good standing. That goes without saying. You have to have your badge, your ID card, no adverse record in your history, and you are a retired law enforcement officer in good standing. Then you receive a handgun permit. The first one was 2 years, and then they went on, your expiration are 3 years from that point on. The abundant amount of initial and renewal applications are enormous. The workload for our investigators to handle the renewal applications take valuable time from investigators. I worked in licensing division for 5 years, and honestly, I felt like I was a hamster on a wheel, the amount of applications you have to deal with. However, our retired officers, that application process would be so much easier and better for our retirees if it were extended to the 5 years. In my opinion, it should be 10 years, but we would be most honored if you would consider 5 years. That's 2 more years than it is currently. Know that our retirees don't stop there. You know, just yesterday, I'm in Easton traveling down the road, and my husband and I, he's also a retired sergeant, and someone falls, knocked unconscious, blood all over the pavement. What do? We stop and render aid. Our retired police officers work as bailiffs. They work in the court system. They do an amount of volunteer work, and we would appreciate your consideration. Thank you for your time.
Now, Mr. Pennick.
Thank you, Mr. Chair. Mark Pennick, President of Maryland Shall Issue. I echo everything that's already been said, and we would ask for the amendment to extend it to all permit holders. Maryland's 2 and 3 year permit renewal periods is an anachronism because it dates back to 1972. Since that time, and that was on a good substantial reason. Since that time, Maryland has gone after the Bruin decision from roughly 27,000 permits in existence to over 159,000 as of August of 2023. That's from the state police. All that big slug of renewals are about to arrive back on the licensing division's footsteps. There is no conceivable reason to go to what we have now, 2 years and 3 years. Almost every major state, including very blue states such as New York, Connecticut, even Massachusetts has 6 years. Florida has 7 years. New York is 5 years. Connecticut is 5 years. Virginia is 5 years. Pennsylvania is 5 years. Delaware next door is 3 and 5 years. Michigan is 4 and 5 years. These states have all realized it makes no economic sense to endure the cost of renewal, and don't hesitate for a moment to believe that those are substantial and they're on the state police and not just on the applicant. There's no reason to incur those kinds of costs when you don't have to. The permits will save the state an enormous amount of money. It will save the applicants an enormous money. It's a rational, good governance provision. It ought to be extended to every permit holder. Thank you.
Mr. Jocelyn.
Good evening, Mr. Chairman, Madam Vice Chairman, John Jocelyn speaking for 2A Maryland. We have immense respect for our law enforcement officers. They do a wonderful job and we commend them. However, we wish for an amendment on this bill to the 5 years to apply for everyone. We believe that the concept of equal rights and protection under the law should apply to all of our citizens. We have a good track record as carry permit holders. There's no reason not to go to 5 years. And as of December 31st, 2023, there were 175,632 active permits. And as has already been noted, these are going to come due in a very short order. We ask for a favorable report on this bill with the amendment to move it to 5 years for everyone. And with the lateness of the hour, I'm going to grant you the last 1 minute. Thank you very much.
Mr. Mohammed.
Good evening, Mr. Chair, Ms. Vice Chair, and other delegates. My name is Galen Muhammad. I am the president of the National African American, the state director for the National African American Gun Association. With the passage of House Bill 824, we have received increased costs for the concealed carry licenses in Maryland. We got this with an inexplicable reduced or a decreased validation period, and the licenses were shorter for less valid time. I support this bill with the amendments already mentioned to apply to all concealed carry or firearms gun permits. Thank you.
Questions? Okay, seeing none, thank you all very much. That concludes the testimony for House Bill 329. Going to House Bill 382, and look who it is. It's Delegate Schmidt. Not Stewart. That already happened. It's Delegate Schmidt with his first bill.
Hey!
Motion for an unfavorable?
Move favorable.
All right.
Thank you, Chair, Vice Chair, and the awake members of the Judiciary Committee. For the record, Delegate Stuart Schmidt from District 33B. Exactly. Professional land surveyors play a crucial role in our society. They are intricately involved in the planning and execution of construction projects, transportation and infrastructure projects, mapping, and of course, defining legal boundaries for land ownership. In fact, every time a real property or real estate is conveyed, the parties rely on the services of the professional land surveyor. Sometimes in the course of their duties, professional land surveyors must enter private property adjoining the areas they are tasked with surveying. This raises the potential for liability under civil and criminal trespass. This bill simply provides an exception for civil or criminal trespass only when the land surveyor is practicing professional land surveys. This exception is not a unique concept. In fact, land surveyors working on behalf of the state are already immune from this liability. House Bill 382 would extend this limited exception to include professional land surveyors working on behalf of private clients. Moreover, 30 other states already provide immunity for trespass or limited right of entry. Accordingly, under this legislation, land surveyors would be permitted to enter the land solely for the purpose of performing land surveyor duties. It's time to bring Maryland in line with over 30 other states that provide this limited, reasonable exception from trespassing. Common legislation protects this vital profession. I would add that there is one piece of opposition, but there is support from the Maryland Realtors, Maryland Society of Professional Land Surveyors, Council of Engineering, Companies of Maryland, and the Department of Labor. Mr. Chairman and committee, I respectfully request a favorable report on House Bill 382.
Good evening, everyone. William Bauer. I'm speaking on behalf of the Maryland Society of Surveyors. Land surveyors have a professional responsibility to protect property rights of the public with accurate and impartial boundary determinations. As part of this responsibility, we are required to collect all relevant evidence when retracing a property boundary. In order to understand the complex pieces of the property puzzle and to accurately identify and sometimes set the property corners as physical points on the ground, we must locate adjoining boundary evidence, which sometimes requires entering property not owned by our client. Additionally, state and local regulations require the precise location of adjacent environmental features and improvements on development plans. Environmental features and private utilities can have setbacks that extend 100 feet or more onto adjacent properties. Likewise, many urban jurisdictions require the location of adjacent structures to ensure conformity of development. All of these regulations require land surveyors to enter adjoining property to provide accurate location data. 30 states currently grant private surveyors either a right of entry or exempt surveyors from trespass. An additional 12 states have limited right of entry for surveyors. Typically, surveyors employed by the state. Maryland is one of those states. Only 8 states have no legislation protecting surveyors from trespass. Land surveyors are only exempt from trespass while performing survey services. This bill would protect land surveyors in Maryland from suits involving trespass while performing survey services. The Maryland Society of Surveyors asks this committee to make a favorable recommendation for the approval of House Bill 382 to allow reasonable access for land surveyors. Thank you.
Good afternoon, good evening, Mr. Chairman, members of the committee. My name is William Kress. I'm here today on behalf of the Maryland Society of Surveyors. I don't often get into this committee, but when I do, I'm always impressed with your stamina. It's been a long day. I think the sponsor and Mr. Bauer have laid out this bill. It's incredibly simple. This would provide an exception solely when a land surveyor happens to enter upon an adjoining property. 30 other states do it. The state of Maryland does it. It's common sense. If you seem to recognize this issue, it's because you heard the Senate bill who crossed over last year, the Friday before sine die. Unfortunately, it did not make it out to the floor to a vote in this committee. I want to thank the delegate for sponsoring the bill this year. It is important. It isn't an issue that happens frequently, but when it does, it's important to have this protection for the land surveyors. So with that, Mr. Chairman, I would ask for a favorable report. Thank you.
Thank you, Mr. Chair. Thank you guys for being here again. So I just want to sort of understand how this would play out. Let's say one of y'all went on the property and, whatever, accidentally left a chicken coop open or a fence open, cattle got out, whatever. So you're not protected from that liability.
That's correct.
Okay, just the trespass alone is what you're asking for protection from.
Correct.
Okay, all right. And then I'm just trying to picture my district. I feel like it might not go over great because we do have some pretty strong property rights ideology. So what happens if, for example, somebody comes out with their shotgun and says, nope, not on my property?
We leave immediately.
A very, very safe choice.
Is it a double barrel or single barrel?
Yeah. So, but it, yeah. would it criminalize them in any way for kicking you off? This is not going to cause them to be in any sort of violation because they've said, no, you can't.
Correct. We would leave, and I know in states that have this type of legislation, we could go and get a sheriff to
Okay.
escort us onto
Okay.
the property.
Yeah.
But if we are asked to leave, we leave
Okay.
immediately.
Okay.
You know, our courts aren't flooded with trespass cases against surveyors because we respect property rights.
Yeah. Yeah. Well, I've never had an issue with you guys. So thanks.
Chairman, thank you, panel, for coming in to testify. I believe your name is Mr. Bauer, is that correct?
Yes, sir.
All righty. So you said you may have to come on someone's property, maybe 100 feet to locate data. Is that correct? Or maybe to locate the point so you can put your tripod on to.
Certain features, tidal waters, tidal wetlands have 100-foot setbacks. So if there is a tidal wetland that is 50 feet over a property line, well, that buffer is going to extend 50 feet onto my property.
Sure, I understand.
Septic systems and wells have similar setbacks.
Yes, I understand. So what's the difference between surveying and surveying services, which you said? You used the term, one time you used the term survey and next time you used the term surveying services.
Well, the surveying services is what we are providing through our location surveys, planimetric location surveys.
If I could just expand, so professional land surveying is laid out in their Practice Act, and they're governed by a board at the Department of Labor. So it's clearly spelled out. I don't know that we have to get into the nitty gritty of it, but
Right, so you're saying clearly spelled out, they're basically the same thing. Is that what
Yes.
you're saying? So basically what you're saying is that you want permission just to walk up on somebody's property, maybe 100 feet deep. Is that what you're saying?
I think what we're saying is we want to make sure we have a good interaction with the neighbors.
Why can't you do you notify the neighbors that you're coming?
Yes, we do.
Like how many days? 7 days, 10 days?
Usually, depending on the size of the project, could be, mailing them within 7 days. Not a lot of people are always checking their mail.
Yeah, certified, certified?
We can do certified
No,
mail.
do you do certified?
We do not,
Okay,
no, but
thank
we
you very
do knock on their door.
You knock on their door.
Yes.
Thank you.
Thank you. Appreciate y'all being here today. Can you just talk a little bit about numbers that y'all are tracking? Do you find that surveyors are being injured as a result of this current practice? And you said to look at ways of protecting them?
When we polled the membership of the Maryland Society, I went around to all of the various chapters and talked to my peers to see if there was a need for this. Most of us had, some colorful stories, maybe having a gun pointed at them. Those are fairly rare. But I've had, people say, get the hell off my lawn. And I complied. But there was a group that was disproportionately affected, and that was our minority surveyors. And that's when I really knew that we needed to pick up the baton on this issue.
Thank you.
Further questions? Second bite of the apple.
Thank you, Mr. Chairman. One last question. If a person has no trespass and no loitering signs up on their door, will you still come up on their door or knock on a person's door?
I do not, and I don't know anybody that would. We would, if somebody has posted their property, we are going to contact
So if
them.
you come to the property, but you need to go another 80 feet to get to your marker point and you see no trespass on their fence or whatever, you won't go in. Is that right?
Well, if we know that a boundary corner is beyond that no trespassing sign, is that necessarily their property? I mean, it's their property as they perceive it. And again, we don't want to create a conflict. So we would.
So you're implying that because the marker is beyond their fence, you're implying that that might not be their property?
Potentially, yeah.
No, that's potentially. I've done surveys, so that's not accurate. Thank you.
Questions, further questions? Seeing none. Thank you very much. That concludes the testimony. Oh, what happened? Oh, Delegate Tolles.
It's really late. I'm sorry. well, in terms of my question, but probably the hour as well. But just really short, what time of day do you go out?
The surveyors get into the office at 7, so if they're going to a site, especially if it's a residential site, we're not gonna get there before, 8 o'clock. I mean, if we have to get there earlier, we would be on our client's property.
Gotcha. So obviously you get permission and you go out, do their surveying, and individuals may or may not be home.
Correct.
But this is just so I can understand a way, like if you have to step on somebody's property to properly survey the property, or I'm sorry, step on their neighbor's property to survey your client's property, it'll give you the ability to not be charged for trespassing. Simple.
Correct.
That pretty
And
much
there are
what it is?
instances where we can collect location data. You've seen the surveyors with the
area.
transit and the
Mhm.
prison pole.
Mhm.
We can get what are called reflectorless shots,
Mhm.
where we're just shooting the laser and it only gives us the location data. It doesn't necessarily give us the elevation data that sometimes we need.
Okay. Thank you, Mr. Chair. Thank you.
No surveys tonight.
Seeing no further questions, now that concludes the testimony for.
Thank you, Mr.
Council.
Chairman.
Thank you.
you.
382. Now, 2 bills. Delegate Carden. Both of them with very skinny files. Very skinny. Christia Pritz.
Thank you,
from-
Mr. Chair,
from
and
the Stiffs and Gifts Law
now-
section. All right.
now I know how you get me to stay here late. I guess I have a reputation. I just want to take a minute or take 30 seconds to say, Miss Pritz has been here all day since 12. And she has watched this, and thank you so much. She does have a family to get home to. I think hopefully you called and told them that you were going to be late.
Yeah.
So thank you very much for being here. These 2 bills were put in on behalf of the Estates and Trust section of the Maryland State Bar Association. This first one, which is 326, numbered second, but we're going to start with it first, is simply a technical change to make sure that that the bill alters a provision that interested parties are the only ones, interested parties or unpaid claimants are the ones that have to be published to make sure that they have the information, not all persons. So everybody in the entire world would have to be made notice of a change of an appointment of a personal representative. And I will stop there and let Ms. Pritz explain everything.
Yes, this is Christia Pritz testifying on behalf of the Estate and Trust section of the Maryland State Bar Association in favor of House Bill 326. So what this does is it makes a clarifying change to the statute that contains the notice that gets published when an estate is open and a personal representative is appointed for the estate. The way the notice is worded now has created confusion in some cases that have been brought to our attention by members of our section, because the way it's worded, it makes it seem like anybody can challenge the appointment of a personal representative. Anybody can challenge the will, but the appointment of the personal representative under law can only be challenged by people who are interested persons in the estate. And interested persons are legatees under the will, or if there is no will, heirs under the laws of intestate succession. So what this this change to the statute would do is break that into 2 parts to make it absolutely clear who can challenge what and where they do have standing. So for these reasons, we urge a favorable report for House Bill 326.
Thank you, Mr. Chair. For the record, John Card on behalf of House Bill 325, asking for a favorable report. This bill alters the definition of an interested person in the Estates and Trusts article by establishing that if you are not, by definition, an interested person, because whatever the reason that you were an interested person has since been terminated, you are no longer an interested person. I'll give you the one example that I understood when it was explained to me, that if you were bequeathed the watch from the deceased and he had already given you the watch before he died, And that's the only reason that you were mentioned in the will, is to get that one item that you already have. You are no longer an interested party because you do not have any interest in the will. Does that make sense? I asked for a favorable report.
Okay, again, this is Christia Pritz testifying on behalf of the Maryland Bar Association State and Trust Law Section in support of House Bill 325. As Delegate Cardin was saying, this bill it's making some clarifying additions to the definition of interested person. And why it's important whether or not you're an interested person is because interested persons have certain rights. They have the right to receive accounting so they can monitor what's going on with the estate finances. If there are any court filings made, interested persons receive notice of that. So we want to make sure that the people who should be receiving those things are receiving them. And also we want to make sure that the personal representative of the estate knows who they're supposed to be giving this information to. So these changes are intended to help improve efficiency, help personal representatives do better to comply with their fiduciary duties. So for these reasons, we urge a favorable report for House Bill 325.
Okay, so I want to make sure I'm clear. If so, in the watch scenario, the watch has not been given to the legatee prior to death, but in the process of handling the affairs, we pass on the watch, right? Because the will says to pass on the watch. Once we've done that, anything after that, that individual no longer would receive correspondence as an interested person.
Yes, that's correct.
Okay.
Yeah.
And so if there are any activities that then cease the responsibility of the estate to an heir or a legatee, once that's done, there are no longer any other reports, they come out of that list.
That's correct. Yes, because at that point they're considered fully paid. So then they no longer would receive information that's in
Okay.
the ongoing.
And in today's world, as I understand it, once you're a legatee, everybody continues to get all of the accounting, all of the reports, et cetera.
Yes, while you are and you haven't been fully paid, then you continue to receive all that information. And that's the way it is now. What that particular change is doing is saying that if your only interest under the will was this item, that isn't even in the estate because it was given away or sold, that once you've been notified of that, you cease to be an interested person, because in that case, you can never be fully paid, which is the way it's worded right now, that you cease to be an interested person once you're fully paid. But in that case, that person is never going to be fully paid. So that's why we're seeking that clarifying change.
When you say they're never going to be fully paid, they've already received payment.
Because if they received it before the person passed away, or if it was sold before. The
Okay,
person.
so this really applies to something that happens before the person passed away.
Yeah, that would cause the redemption that's being addressed in that provision.
Okay.
Yeah. Mhm.
And it will save the estate quite a bit of money, which is good for all the other interested parties as well.
When you say it saves money, I'm not sure how it saves
Well,
money.
if you're reducing the number of times you have to communicate with that party that no longer is going to be receiving it because they're no longer an interested person, it reduces the amount of time spent on the estate, it reduces the amount of postage or other communications, and that could increase the value of the estate, which would be then given out to the interested parties appropriately.
Chairman, thank you, panel, for coming in to testify. I believe I heard that if the person who died left just the watch to a certain individual, that person would only be entitled to the watch. Was that the example that you gave?
That's correct. Yeah, if that's the only.
So that's after
request.
death, right? That's after the when they're dealing with the estate after the person has died. Is that correct? And they transfer the watch to.
Yes, yeah. So the will says to give it to that
Yes,
person.
I
and
understand.
they-
So this gentleman, let's say, has 3 sons. He specifically says he's leaving this one watch, the Rolex, to one son, but he's leaving his Rolls Royce car to another son, and the rest of it, whatever. So now you're saying that the 2 sons wouldn't be entitled to the remaining 2/3 of the estate? Is that what you're saying?
Well, it depends what the will says. So if
No,
the
no,
will.
but you said specifically if they said this
If-
watch, or do we have to say
if the-
only this
Oh,
watch?
if the only thing that the will says for that person, that particularly is that one bequeath. or
See,
bequest.
I leave my son Frank this watch, and I leave
Right.
Delegate Carden the Rolls Royce. And now I have another 100 cars and another 100 watches. And we
Right.
have a third son here,
Right, well,
and we haven't left him anything.
It depends on what the will says.
But I can't vote against your bill, so thank you.
Thank you, Mr. Chair.
Delegate Tolles, which I really hope is the last question on this bill.
Let's just say the one thing is something of more substantial value, like a house, and they left that and say, you know, say it's a child living in a house, and they left the house. That means they no longer would be, and that's the only thing that's left in them. They have it, they living in it. Would that apply in this situation where they would, what were your words, no longer interest because they're fully deemed cease to be an interested person because they received that payment of notice?
So that beneficiary would continue to be an interested person. If the house was all they were receiving, then until the deed is signed to convey the house to that beneficiary, they haven't been fully paid. So
Well,
they'll
let me
continue to
just,
receive
well, that's
notices.
maybe not a bad example because you got to go do title and all that stuff. So let's just say, again, my point is something where, you know, say it's use Delegate Conway's example of a car, you know, what is that? Well, let's just say the house has been titled and, you know, to them. Then
And-
what?
and
They
it's
will
the-
be taken off. They would.
It's the only thing that
it was given.
that was given to them in the will.
Mm-hmm.
So as soon as they take full possession, whatever is required by law,
Mm-hmm.
then they would cease to be an interested party at that time.
Yeah, and that's what the law
Regardless
is
of the
now.
size.
That's the current law also now.
Okay, so then if that's the current, so tell me what you're changing it to, because I thought that's what you were changing it to.
Yeah, no, what that provision is changing is the scenario where that item is gone. It's not in the estate because the person who owned it before they died, they either gave it to someone while they were living or they sold it. So it's not there. So the will says, I give this item to this person, but the item's not in the estate. It's gone because the decedent gave it away. So that person really shouldn't be participating in the estate administration because they're not a beneficiary because what they were supposed to receive isn't even in the estate. It was given.
So you
away
mean
for-
that person didn't put it in the will? So the person did not put it in the will, or they did put it in the will, and they said, because your scenario,
Right. I
Delegate
put the watch, I give the watch to you in my will.
Is it a Rolex? Because if it's not, I don't want it, but go ahead. I'm
It's a
sorry.
Raymond wheel.
No, I'm good.
Okay. I give the watch to you in my will, but before I died, the nurse was taking care of me and I gave her the watch right before I died.
Mhm.
The watch doesn't exist anymore as far as the will is concerned. Therefore, you no longer, because the watch is no longer in my possession, I can't give it to you. The same would be true if I gave it to you before I died. You came to visit me in the hospital.
Mhm.
I gave you the watch. This is also in this scenario, right? The watch doesn't exist as far as the will is concerned anymore because it's already out of my possession.
Okay, so, okay, you're saying, and we can talk offline in the essence of time, but I just want to make sure I understand fully for the record that you left the watch to me in the will.
The watch is no longer in my possession.
No, I'm saying, okay, you left the watch in the will, but you gave it to the nurse that you thought was cute or something. I don't know. You gave it to the nurse. And so it's no longer for me to have. And so it's because even though you put it in the will, and it's since it's not in your possession anymore, then the watch doesn't belong to
It
me.
no longer gives you the right to be an interested party for the purposes of.
Interesting. Okay, definitely something to talk about. Okay, thank you. I'll stop there. Thank you, Mr. Chair.
Are there further questions? Delegate Conaway? Seriously, no, just to be fair, I mean, if he if he had another question, I was gonna call him back. But he does not appear to be coming back in the room,
Thank you.
and he'll ask his question offline. Seeing no further questions, that concludes the testimony for House Bill 325. Thank you all very much. That concludes the testimony for today. We are here tomorrow at noon for the bill hearings. Thank you very much.
Really appreciate it. I'm gonna wait. I was gonna wait and I put you.